please?
Oh, sure.
Okay, thank you so much.
No problem. Yes, Gary's been with us a couple of times. He's given some great, I think this is maybe his fourth or fifth presentation, always informative information. His last one was about his own startup business, very informative and interesting to follow his path. Gary received his law degree from Rutgers University in Newark and his geology degree from Rutgers University in New Brunswick. Before his role as managing partner at Katz Law Group, LLC, he was a partner at Fisher Broyles, worked as a patent attorney for Matthew Lawson, McCutcheon and Joseph P. LLC, and served as in-house patent counsel for ExxonMobil. And without further ado, I give you Gary Katz.
Okay. Thank you, Alex. I'm going to share my screen. Let's go to the thing, and then let me make it full screen so everyone can see it. Okay, does everyone see it? Give me a thumbs up.
Mm-hmm.
Awesome. Okay. Yeah, so thank you for the introduction and what I've been asked to speak about, and I'm happy to do and share my knowledge, is intellectual property for startups and small businesses. Obviously, there's different considerations for a startup or a small business versus a large corporation. So we have to be very mindful of the costs involved and and what are the benefits of each form of intellectual property. And by having a basic understanding, the hope is that we'll be able to better guide a strategy before working for a startup or small business. Typically, the larger corporations, they already have a strategy in place. So when employees join them, they're just following the corporate strategy, which doesn't change very often, versus the smaller businesses expect the individual employees. So I guess being a lawyer, I always have to give some type of disclaimer that this is for informational purposes only. It's actually going to be a very basic review of intellectual property. Obviously, if you have a question or need legal advice, you need to speak to an attorney and explain the whole situation. So now I decided that this presentation is going to be about an hour, and we're just going to deal in the very basics of each form of intellectual property and mention the considerations. If anyone has any questions or wants me to go deeper, feel free to interrupt me and we can discuss it further, or you can save the questions for the end. So, okay. So I guess this slide isn't needed on my background because Alex did a great introduction. So I'll just give a few highlights. So I'm a patent attorney. I've been doing this for over 20 years. I've been working mostly in patents, but doing all forms of intellectual property. 10 years of that was with ExxonMobil as an in-house attorney, both for upstream research and for downstream with research and engineering. I have 10 years with large and small law firms. So basically, I've been with a large law firm, I've been in-house counsel, and I've been in a small law firm, including solo practice, which I have right now. I've drafted and filed well over 100 US patents. I've worked on at least 1,000 patents worldwide. And in addition to my my legal experience, I also launched a startup on water purification. So we had to file quite a lot of patents. In fact, I filed 13 patent applications. So far, 3 of them are issued and 4 have been recently allowed. So I actually have a very unique perspective when it comes to intellectual property because I've seen it at multiple angles. I've seen it with the large corporation where we spend tens of millions a year on intellectual property, actually much more than that. I've seen it from the perspective of a large law firm. I've seen it from a boutique law firm, and I've seen it as a sole practitioner. Now, recently, I've also have the perspective of a startup or a small business where costs and obviously bootstrapping is part of it. So you have to be very aware of the costs involved. So I think I have a unique, multifaceted perspective, which I'd like to share. So, what is intellectual property? So, this is a definition that's given from the World Intellectual Property Organization. I gave a link on the bottom. They have some great material. In fact, most of the material for this presentation I took from them. So intellectual properties is a property or asset, but it refers to the creation of the mind. It's more of an abstract, such as inventions, literary works, artistic work, design, symbols, names, and images used in commerce, both business to consumer and business to business. So the main examples are patents, which are people are most familiar. Those cover inventions, and we'll discuss the difference between a utility patent, which most people associate patents, and then design patents, which based on a recent decision have become much more important. Copyrights, which obviously refer to literary works and sometimes artistic works. Trademarks, which is a design or symbol that's attached to a product traditionally. Publications are also a form of intellectual property. They serve many purposes. And then trade secrets, where it's hidden from the public. The biggest, best known example is Coca-Cola. And in order to fully create a knowledgeable or intellectual property strategy, you have to have at least a basic understanding of each one and how they interact with each other. So let's start with patent. And what is a utility patent? So a utility patent is an exclusive right granted by a government to an invention. Now, it's very important that the US Code gives the patent holder an exclusive right to exclude others to make, use, offer to sell, or sell any patented invention, both indirectly or both directly, indirectly, or even contributing. If two or more people work together to infringe on a patent, that's still violation and infringement of patent rights. So this is a very valuable monopoly, giving you such a strong monopoly that you have the right to exclude anyone else. Now, it's also for a limited time because the framers of the Constitution intended for everyone to benefit from the inventions. So the inventor benefits by having a monopoly for a period of time. Society benefits from the disclosure of the ideas because you have to disclose it, and we'll mention the detail, you have to disclose it later. And once the monopoly is over, it's considered dedicated to the public domain and anyone can use it. So the whole idea is to advance the scientific discoveries by giving people an incentive to disclose of it and then giving it to society, or what we call putting it into the public domain. Now, there's three main requirements to get a US patent. You know, under the US law, you're entitled to a patent as long as it's useful subject matter. It's got to be a composition of matter, machine, a industrial process. It's got to be novel. Now, novel means it's got to be different than what anyone else has done before. And it's got to be unobvious. Now, most of the time, when you're trying to get a patent, the issue is it unobvious? Because you could always find some difference. The question is, are these differences an obvious difference or an unobvious difference? So the classic definition of an obvious difference is when you take two or more known products and use it for the intended purpose to get an intended result. So even if you take A, B, and C, and use it exactly as it was intended and get the intended result, that's considered an obvious combination of known technologies and exclusions for getting patent. Now, where a good patent attorney comes in and why it's very important to understand this is there's ways to get around that. For example, if you're using it in a way that's not intended, that is a way around an obviousness rejection. If you get unexpected results, that is a way for obviousness rejection. If you're combining it in a way that the references say you shouldn't or can't do it, that is a way around an obviousness rejection. So what is very important when you're drafting this is to include tremendous detail. A lot of my clients are like, why are we spending so much time adding more and more detail? Well, the reason is you never know when the detail we're putting in is necessary to get around the rejection. So it's always good to do a search. It's always good to understand what's out there and know why you're different, provide the benefits, and also provide all the detail it allows you to get around when we have these discussions or what we call prosecution with the U.S. Patent Office when they determine whether or not to issue the inventor a patent. Now, the most important thing is the invention is what we call enablement. That's on the bottom of the slide. The invention must be fully disclosed and published. And what that means is you have to provide enough detail to that one skilled in the art can make and practice the invention without undue experimentation. So essentially, you need to disclose all the essential elements. You also need to disclose the best mode. Now, a lot of times inventors are like, well, I don't want to disclose the best mode because people will know exactly what we're doing. So in that situation, what I tell them to do is, if it's a chemical composition, list all the different combinations. As long as your best combination is disclosed, you've met the best mode requirement. But if you're listing every combination in the book, any reader is not going to know what the best mode is unless they experiment and try all of them, which is very difficult or probably practically impossible. So even if you don't want to disclose the best mode, you have to, and there's ways to protect it around that. And that's something you need to talk to your patent attorney. So what are some considerations for patent? We mentioned that it's a limited monopoly. You have 20 years from date of filing. So a lot of patents are what we call paper patents. They're either too early or too late, or there's not a need for it. So sometimes being too early is not a good thing because by the time your invention becomes needed, after 20 years, it's considered dedicated to the public. So one of the things is, and this is beyond the scope of the presentation, is if you're going to go to time and expense of filing a patent application, make sure the invention solves a problem that the customers will actually pay for. So that's part of the lean startup model. Maybe we could give a talk on that, is when you're creating a startup or a new business, you always need to make sure that whatever your intended product or service or solves a problem, enough of a problem that someone will actually give money to actually pay for it. Now, in the startup world, that's called the minimum viable product. I've heard it crudely described as the cheapest piece of crap that some poor bastard will actually pay money. So because it's a limited time, you have to make sure that there's a marketplace need, or else you're just filing what we call a paper patent. And even if it gets issued, it doesn't have much value if it doesn't give any value to the point that someone's going to want to use it. Now, this is very important. A patent and a lot of people get confused on this, is not a license to manufacture or use. It's a monopoly or a right to exclude others. So a lot of people say, oh, I'll file a patent, I have a right to use it. Not exactly. You could have patents that overlap, in which case you need a joint license. You could have someone have the pioneering patent, which discloses the base technology, and you're just an improvement. At that case, uh, if you're using the base technology, you need a license for the base technology. And if you're using improvement, you need a license on the improvement. So what if you want to know if you have a right to manufacture or use it, you need to what we call an FTO, which is a freedom to operate. And that's typically a legal opinion, and it's a very detailed opinion. First, you have to describe what you're doing in great detail. You then have to do a search. A lot of attorneys use outside searching firms, and they look and find all the patents that are relevant to that. And then we look and see claim by claim if what you're doing would infringe upon any patents. And then once you have that, we either get a clearance letter or a letter that raises issues, and then you have to make a decision. Do I want to get a license, design around, or sometimes, unfortunately, people take the risk of infringing patents, which is very risky. International treaties. The main one is the PCT, which is the Patent Cooperation Treaty. That's, I think, now 163 countries. Most of the countries in the world, there's only a handful of countries that are not part of it. And the Paris Convention, the PCT is actually a follow-up to the Paris Convention, and that covers foreign filing. So the Paris Convention, once you file in any country that's part of the Paris Convention Treaty, you have a year from that filing to file in any other country and still claim priority. And the PCT is actually a semi-prosecution body where they review a patent and issue a patentability report. We'll discuss it more. And that gives you the ability 30 or 31 months later from the priority date to actually file in those 160 countries so that you can, with one filing, be protected throughout the almost entirely throughout the world, and then decide which countries later you're going to go national phase. So it's actually a good way of postponing the cost to give you time to bring it to market and determine the value. So we mentioned that there are different types of patents: utility, which cover the inventions; plants, which are biological patents covering plants; and then design patents, which cover the ornamental design, can't be functional. So the most famous one, which we'll talk about, is the iPhone versus the Samsung. Now, you also have to know about provisional and non-provisional. So in the US, which is the only country I'm aware that allows this, allows you to file a provisional, which gives you patent pending status. And the provisional isn't examined. It's only good for a year, and it has a very low standard. Basically, you have to disclose a enabling invention, which is enough information to practice the invention. And then in a year, you have to file a non-provisional where you could go ahead and meet all the requirements, formal drawings, claims, everything has to be in the format they want, and that gets prosecuted. So I see two questions. I'm going to go to it and see. Okay. Guys, 30 minutes. Okay, so the intro, I think some people thought the intro was too long. Please give us an idea of the cost of a utility patent from A to Z. Okay, I was going to discuss that later, but I'll discuss that at least initially. So utility patents are not cheap. It could be a minimum of 4,000 to 5,000 if you go with a small attorney like myself. A mid-sized law firm is probably going to charge you around 10, and then some of the larger firms 20,000 or more. So it's not cheap. It's very expensive, and it's also very time-consuming. So before filing a patent, you need to make sure that that the value's there for you. Now, one of the things is that a lot of startups I deal with, they'll go talk to a large firm and they'll tell them they need a budget of 20,000 for a patent. They have several patents, and there'll be $50,000, $60,000, and half of that they need up front. And a lot of startups, unfortunately, say, I can't afford that. Unfortunately, they don't know better and they don't hear from others. You can go to a small law firm, which will probably charge about half, or you could go to a solo practitioner who will probably charge a fraction of that and probably get the same value of service. Also, what a lot of people don't realize is these big law firms heavily discounted for the corporations because they're doing volume work. So don't be afraid to ask for a discount. Uh, they're charging probably under 10,000 for big corporations because they're negotiating. So feel free to negotiate. Now, obviously, you don't want to negotiate too much that the attorney will just not be worth it or won't do a good job. So you have to, and a patent is a very detailed document. Judges have described it as probably one of the most difficult legal documents to draft. If it ever gets into a lawsuit, every word is going to be challenged. So you don't want to make sure you say anything because that could hurt you in a trial. So to do it right is not cheap. It does have tremendous value if done right, and it protects a valuable invention in the marketplace. So that leads me to the next point. Expensive and time consuming, several years and thousands of dollars in each jurisdiction. Now, the prices I mentioned were just for the US. If you go international, we'll talk about international later. International gets ridiculously expensive. You could spend hundreds of thousands of dollars filing patents throughout the world and hundreds of thousands of dollars filing all sorts of trademarks and other things. So I've come up with foreign filing strategies that are much cheaper and cover most of the GDP of the world for much less. But that's something we could discuss later. So one very important point, and this is on the bottom of the slide, use in commerce is a bar to patentability. I'll repeat that. Use in commerce is a bar to patentability, and the date is critical. Okay, now in the US, you have a 1-year window of opportunity. Now, in almost every jurisdiction in the world, any commercial sale or offer to sale is a bar to patentability. So what is a commercial sale or using in commerce? Most jurisdictions, including the US, say if you offer to sell it, that's use in commerce. So if I were to go to Carlos and say, Carlos, look, I have this great invention. You want to use it? I'll license to you for $1,000, and we could and you can use it. And Carlos says no. That is a commercial bar. So most of the world, you're barred from patenting. In the US, that starts the 1-year rule. I think I see some more questions. Okay. Regarding patents covered internationally, how protected are we? Which countries are the most famous for breaking the patent laws? So I guess we'll discuss it later, but it really depends. And basically, if you want to, the easiest way to tell the enforceability of a patent is how good the judicial system is. So a lot of people use, there's corruption indexes and a list on the judiciary. So most people say that if they have a good court system and they're not corrupt, you have a valuable patent. I guess hopefully I won't offend anyone and get in trouble. One of the biggest known jurisdictions for stealing patents is China, and the good news is they're getting better. The bad news is they have a ways to go. And I've been to a technology pitch in China with my startup, and I realized that what was refreshing was the Chinese realize that intellectual property is a problem in China, and they realize and they realize they have to do something for two reasons. One is uh, people are not investing in China because of the enforceability of patents and theft of IP. Now, if you're as big as Apple, you can negotiate with the government. Now, the good thing, Apple's not worried about their intellectual property because they have agreements with the Chinese government. And the Chinese laws are so strict that theft of intellectual or patent infringement is actually a criminal act. So it's known that if anyone tries to steal any of Apple's IP, they're going to go to jail, maybe will never be heard of. So, but that's Apple. Most of us don't have the political clout and economical clout of Apple. So you need to be careful. There's ways around it. It's beyond the scope of this discussion, but one way is to have agreements with people well connected with the government and make it worth their while to enforce it. The other way is make it very clear that the technology is going to improve over time. And if there's shenanigans with the intellectual property, you're not going to do any business with them. So make that clear up front. I'll give you an example. In China, I had a client who I did some patents for, and we did a patent on a new prototype they were working on. They were basically a software company, but they were looking into some hardware devices, and they decided instead of using rebranding someone else's hardware device to come up with a new improved version. And they built about 100 of them, sent it to their manufacturer in China, and sent them out to customers to beta testing. And there were a lot of problems with these prototypes. So the company decided to fix these problems would not be worth the effort. And what happened is that they just decided to abandon it. About almost a year later, on Amazon, they were getting complaints about this product and asking for returns. And they asked one of them to send it to them directly. And it was the exact product that they beta tested that they sent to China and had their logo and everything else. So, of course, they went back to the manufacturer and said, why are you doing this? And they said, we don't know anything about this. They said, you were the only ones who had the designs and the plans that would know even to copy it. So they stopped doing business with them, but that just shows what you're up against. So it is getting better, and I think China has a ways to go. It's also patent theft and intellectual property theft. It's also a problem for Chinese startups. I remember meeting a smart light company, and one of the questions asked was, "What is your biggest difficulty going forward?" And they said that IP theft. Whenever they introduce a new product or design, someone copies it. So I asked them if they looked into patenting it, and they said it's very hard to enforce in China. So even the Chinese are realizing that if they want to promote innovation inside the country, that they have to provide intellectual property. So, and it's not just China, but China is probably, because of their size and because of their importance, the best known example. Okay, so I'll go to the next slide, and we'll talk a little bit more about international filing. Okay, I'm trying to get to the next slide. Okay, Okay, so what is a design patent? And this is a slide I actually recently added in the when I first got into intellectual property, design patents weren't considered very important. Now recently they've become extremely important. So what is a design patent? A design patent is a form of legal protection granted to cover the ornamental design of a functional item. So a patent covers the functionality of, of a device, a utility patent. A design patent actually covers the ornamental design. Now, what is an ornamental design? It's a design that has nothing to do with the functionality of the item. So if the design or the pipes or is for a functional purpose, technically you can't get a design patent, you need to get a utility. So if you're having lines in order to make it easier to manufacture, then that is a utility patent. If it's done purely for the ornamental design, then you should get a design patent. And there's some differences, we'll discuss it. So the most, so some of the more famous ones is the Coca-Cola bottle. You could see from 1915, Samuelson filed a design patent covering the unique ornamental design of the Coca-Cola, which allowed for decades people to recognize that as Coca-Cola container. Now, I mentioned in the past design patents were not considered very valuable. That all changed several years ago when Apple sued Samsung for infringing upon their design patent and won $1 billion judgment. Apple won $1 billion judgment against Samsung, and that changed everything. So this is a figure that was used in Apple's lawsuit against Samsung, and you can see the drawing, and it's very important to have a professional drawer draw your of their early iPhone. Now, what's important is you could see the solid lines, which include the what's claimed. Anything that's dashed is not claimed. And this became very important for the Apple because Samsung said, look, yeah, there's some similarities, but we're not different. You look at the top is different. We don't have that circular button, and the back is different. And Apple was able to come back and say, you see those dashed lines? Those dashed lines mean we're not claiming it as a design. Our base design are the solid lines, and there's no difference between our solid lines and Samsung. And because of that, they got $1 billion judgment. And overnight, that changed the thinking. And design patents went from something you file as part of an overall strategy to extremely important. So we'll go back. Okay, so that's basically patents, and we'll talk a little bit about international more later. So what is a copyright? So copyrights are rights that creators have over their literary and artistic work. Now, there's two main requirements. It must be original, can't be an exact copy or someone, and it must have some minimal creativity. So, pictures, it's all about the light. Artistic works, obviously, there's creativity. So as long, it's a very low standard. So as long as it's original and it took some creative effort by a person, you can get a copyright on it. Now, people have gotten copyrights on books, music, paintings, sculptures, films, computer programming. You can even get it on a database, both the data inside and the formatting, the advertisements, maps, technical drawings, and even websites too. So advertising material. You register at the US Copyright, there's a link. And it's very important because it provides statutory damages. So you don't have to prove damages. If you have a copyright and someone violates it, you get statutory damages. It's inexpensive to file and it's easy to register. between $35 to $85 on filing fees. Now, for all those that are do-it-yourselfers or don't like to pay attorneys, and let's face it, everyone, attorneys are very expensive. This is one area where if you're detailed oriented and you want to do it yourself, there's very little harm in doing it. It's basically filling out a detailed form. Takes someone who knows what they're doing about an hour, maybe first time 2 to 3 hours. As long as you could, you could follow instructions, you'll probably do it right. If you don't do it right, just file it again. So if you want to do it just to experience it, or you need to protect something and don't want to file an attorney, go ahead and do it. It's one of the areas where you can read about it. You can spend some time reading the instructions online, and I would say 95% of people will get it right. So you have the statutory damages. So it's a minimum of 200 plus attorney's fees, and that's only for the innocent infringer who didn't know what they're doing. It's actually 150,000 willful or infringement plus attorney's fees. So the damages could get pretty high, particularly if someone knows about it. So typically, if you're not sure, you send someone a cease and desist letter letting them know that it's under copyright, and some people call it a takedown notice if it's on a website. And if they don't do it, they could be in serious trouble for willful infringement plus the attorney's fees. So it's actually has some strong protections. Now, copyright lasts for 70 years, typically after the death of the author. There are some exceptions to it, but most copyrights, it's the life of the author plus 70 years. And typically the author who does the original and creative work owns the rights. There's an exception. It's called work for hire. So if I pay someone to do it, it's called work for hire, and that belongs to the person. Now, one thing to remember is if I pay an artist or commission an artist to do a painting or a sculpture, I own the copyrights because it's a work for hire. However, if an artist does a sculpture or painting and just sells it to me and there's no agreement, the artist still owns the painting and copyright. So a lot of people buy artwork and then they see the artist doing an exact copy or something very similar, and they're like, you can't do that. I own it. No, the artist owns it. Now, unless it was a commission work for hire. Now, what I recommend is you have a legal agreement over who owns the copyrights. So to make it clear, even if it's a work for hire, the artist could come around and say, look, I was just selling them an artwork. It wasn't specific to this one. So if you need to own the copyrights, you want a simple agreement, copyright transfer. Now, another one to keep in mind are fair use exceptions. Now, there are a bunch of exceptions, and we can go over your federal law, but if you're going to use it for a non-commercial use for your own benefit and there's not going to cause tremendous commercial harm, that's called a fair use exception, such as teacher copying parts of a book, someone reading it over as part of a speech. Important to always note that if at all possible, you're borrowing it from someone else, but there are obviously exceptions. However, if you're selling someone else's work, that generally is not a fair use exception, except for parody. If you're making fun of someone or criticizing, that generally is. Okay, I see a bunch of questions. Okay. Okay. Do you run a risk of infringement when attempting to copyright something like a logo that may be similar to another company logo? So we'll discuss that later. Now, a logo is typically a trademark. because that's a design that's associated with a product service. So let me talk about that later. If I don't answer it, Doug, sufficiently, feel free to raise again. Any famous copyright cases? Yeah, there's been quite a bit of them. I know Google just got into one on, it was considered a copyright case of the decade, dealing with, and the Supreme Court is about to issue a ruling on it, where they use some code from JavaScript. Google said that it was insignificant and also claimed fair use. That was the only way of doing it, and they only copied a few lines of code out of hundreds of thousands of code. So the Supreme Court has a big decision on that. Do the functional patent and design patents need to be separate, or can you do both in one document? Absolutely, they have to be separate. Now, one of the things you have to be cognizant of is a functional patent, and I assume you mean a utility patent, that covers your inventive concepts, the functionality of it. The design patent covers the ornamental. Now, if they see the exact same drawing in your utility patent as in your design patent, they could say, look, the design patent's invalid because it covers a utilitarian function. I mean, it covers it's done because it provides improved functionality. So really what you want, and this is why you need to be very considerate and have a good attorney working for you, is you want your utility patent to cover the functionality, the improvements over the prior art, anything that gives you a improvement in the technology. And you don't really want to disclose the ornamental designs in the utility. The design patents should cover the utility patents. So for example, take like the Jeep, which has a unique, Chrysler Jeep has that unique grille system in the front. They have a design patent on that and copyrighted that. So the engine itself would be a utility patent. The grill cover and maybe the air intake system, if it has improved size or allows for improved on that grill, would be a utility patent. The grill itself, how many lines or what size and what shape, that is a design patent. Okay, so the answer is yes, it needs to be said. Wasn't there new federal legislation in the last couple of years? If so, we addressed the changes previously. So I'm not aware of any major changes in copyright. I know there's been a lot of discussions on what's allowed on the internet. There's been legislation on the takedown notices. So one of the areas is that as long as you have a takedown notice where if someone posts on your website infringing copyrighted work, that provides some liability relief. What kind of patent was the sound of a Harley Davidson motorcycle? We'll go, Francisco, that's actually a trademark. That's a non-traditional trademark. Like certain distinct sounds like the NBC TV sound and others can be trademarked because that's associated with the good. So let's hold that for a trademark. So, and then I borrowed from someone else a good graph that shows the differences between design patents, copyrights, and trademarks.
Thanks.
All right, no problem. Okay, so I think we did anything on this. Is everyone clear on the copyright? What is a copyright? Okay. So What are some of the international considerations for copyrights? One of the amazing things with copyright is it gives you automatic rights worldwide through international treaties. And the most important one is the Berne Convention. So there are three principles that it follows. One is national treatments. So a work originating in one of the contracting states, and the U.S. is the contracting state, will be given the same protection each of the other contracting states as the letter grants to the work, later grants to work of its own nationals. So once you file a U.S. copyright or you claim copyright in the U.S., you automatically have copyright protection throughout the world. This is very valuable. It's automatic. That's the second part. You don't have to do anything about it. There's no formality. Now, some countries have registrations, which similar to the U.S., but that's just a formality. But your copyright protection starts immediately from the point you created the U.S. It's independence. Their protection is independent and existent of the protection of the origin of the work. So if you were to sell the rights of in the U.S., you still have rights throughout the world. So obviously, when you're drafting copyright transfers, you want to make sure it's clear that it covers the world, right? And recently, there was a WIPO copyright treaty, and that covers digital works. And I got to admit, I don't generally handle digital works. I can file it, but I do know there's been a lot of discussion recently in court cases on digital works. So if anyone has any specific questions, I'll be happy to look that up. All right. Looks like we got two more questions. Let me go. Okay, there we go. Let's go see the chat. What about trademarks and international registrations? I'll get there. Will fair use be discussed? I guess I could maybe. I touched on it briefly. So maybe what we could do is when I'm done, we could pull up the U.S. code and discuss it and some recent cases on that. Okay. Trademark. So I'm glad we did this. So what is a trademark? A mark. It's this is a traditional trademark. We mentioned sounds or smells as non-traditional trademarks. It's a word, a phrase. So a word would be a traditional trademark. A phrase would be a service mark, like Snapple, which was made from the best stuff on earth. A symbol, which is a logo, could be a design and it overlaps with the design, or even a combination of all that. And what this mark does, it identifies or distinguishes goods or services from one entity from another, or one commercial entity or enterprise from another. So there's several considerations. Now, the standard of infringement is a likelihood of confusion standard. So if you're likely to create a confusion with someone else's trademark, that's infringement of trademark. One of the things is that, and I'll discuss this a little bit later, is people like to have similar trademarks over the market leader. And for many reasons, both legally and from a business standpoint, that's not advisable. Legally, if the similar you are to some other name, the more likely you are to infringe. But also from a market standpoint, in the long run, it's not good because you want a distinct name so that people will recognize your product distinct from everyone else. In the marketplace, you want to win because your product is known to be better than everyone else, and everyone looks for your product. So trademark, there's two types. Generally, it must be used in commerce. You must use it to offer that good or sales. Now, in the US, there is an exception for intent to use, and that gives you a limited number of time. So if you want to protect it and you're not using it, you file intent to use, and then you have a certain amount of period of time to actually use it to commerce. You must, for both of these, provide a specimen. If you're using it in commerce, you must provide it at the time of filing. That's showing the mark being used in commerce, typically a website or a presentation or sales brochure, or actually a picture of the product itself. Okay, now there's 4 main categories of trademarks. We'll go over them, and I thoroughly placed them from the most valuable to the least valuable, or the ones you cannot get a trademark. So the most valuable patent, trademark, is a fanciful name. Google, Yahoo, the name has no meaning whatsoever. So that's what we call fanciful. And those are the best names because they are the most protectable. It's easy to get a trademark, and it's easy to infringe that mark. No one, Google has no meaning. So any similar name to Google is going to cause a confusion in the marketplace. So if you go Foogle or Goofle or something like that, you're going to be in trouble with Google because it's a fanciful name, and obviously you're trying to use the goodwill of Google. So that's probably the strongest type of trademark you can. So I recommend to all my clients, don't pick a name that is fanciful, because if you make it big, you're going to have a very easy mark to protect and a very valuable mark. So an arbitrary is a name that's known but used in an arbitrary manner. For example, Apple. We all know what Apple is, but the association with Apple to computers is arbitrary. So that's actually considered a strong, semi-strong trademark. Now, less strong, but you can get it, are suggestive names. Jaguar automobile. Now, a Jaguar denotes being fast. So you're suggesting something. Now, you can get a patent, but, the courts recognize that just because someone calls it Jaguar Lounge or a Jaguar cat that's similar to the Jaguar, you're not going to get as strong protection. Now, even less protective are descriptives. The example would be American Airlines. Now, it's very hard to get a descriptive trademark allowed. You have to show secondary meaning. Now, American Airlines, while it is a descriptive mark, people over the years and decades, people have come to associate it with a certain type of company. So they're able to get a trademark. However, for most people, you don't want to spend years or decades creating what we call a secondary meaning to the descriptive term. So generally speaking, you want to avoid it. So even though it is possible to get a trademark, it's not the best when you're starting out. And then the one trademark, which actually you cannot by law get a trademark, is a generic name. So if you put out a sign that says shoe store or pharmaceutical store or a supermarket, that's generic. It describes what everyone else is doing, and by law, you cannot get a trademark. So one thing is trademarks are moderately expensive. Typically, with legal fees, you're talking $1,000 to $3,000. It's not very time consuming. Maybe once you have a name, we do a search and we file it, and within usually 4 to 9 months, you'll get back in office action. And typically, you could have a trademark in under a year. Okay, I see another question. Please compare and contrast trademark and trade name for protection purposes. Aren't they sometimes the same being used? Do service marks have trademarks? So, okay, so I guess a trademark would be a logo. So a logo would be, say, the Apple of Apple computer. So you see that very colorful apple, and you immediately associate it with computers or electronic products, the iPhone from Apple. So that would be a trademark. The trade name would actually be the word Apple, and a service mark would be a slogan that they use. So I'm probably going to date myself. I think most of the people are my age. Remember when Apple came up with those famous commercials, Think Differently, and they had all the people who thought differently, and they promoted being a misfit and being the square, the round, uh, the square peg that wouldn't fit in a round hole. So Think Differently would be an example of a service mark. So each one of them is attached with a product or service. Yes, they're overlapping, but each one of them would require a separate trademark. Now, trademarks also have international classifications, and you typically need to have a trademark for each classification. So if you have a car and you wanted to have automobiles, that would be one trademark. Want to use the car for a service, a taxi service, that would be a separate trademark classification, and each one requires a filing fee. If you wanted to use, say, Jaguar to create a lounge, you would have entertainment or restaurant. That would be a separate one. So it's important to recognize it. What happens to the old logos when logos are updated? Apple, for example. So if it's substantially similar, you probably don't have to update it. If it's a very valuable logo, every time you probably want to update it. So if it's a very minor change and it will still cause confusion, yes, the Apple logo changed over time, but the basic Apple from the Macintosh versus the new one still looks the same. So if you put an Apple on a computer, you're going to cause confusion. But I'm pretty confident that Apple has filed multiple trademarks on every version of it because they're very aggressive. And again, that's the distinction of being a major corporation like Apple. They spend tens, if not hundreds of millions every year protecting your IP. Small business has to be smart about it. So you probably want to pick a design that covers multiple embodiments and the most common design that you intend to use. What happens when old logos? So if it's a completely old logo and you're not using it in business, at that point, you lose the trademark. So if you're not using it or enforcing the trademark, over time it's lost. And that can be very important because sometimes companies let a logo go and then they bring it back. And the question is, could there be a break? For example, Tony the Tiger and the ExxonMobil Tiger got into a trademark dispute. And one of the issues was Tony the Tiger from Kellogg's was predated the ExxonMobil Tiger, which was then being used to sell branded food at the gas station. However, there was a period of time when Tony the Tiger was not being used. So the question is whether over that period of time, Kellogg's had abandoned the trademark. That case was settled, but it just shows how important. Also, sometimes companies will, if they don't want to lose the trademark rights, will just use the old trademarks or old logos on goods that are being in commerce just to maintain the trademark. And I didn't mention this, you have to renew the trademarks every so often by filing statements of use, 3 and 7 years. Over a period of time, the longer you have the trademark, the harder it is to contest it. Okay, so I got a request. Okay, I got a request to, I guess, instead of asking questions, to hold it at the end and answer it. So, okay, so I'll do my best. I'll talk through it. If I'm missing a point directly, feel free to interrupt me. If not, we'll give plenty of time to talk about it at the end. Again, I'm not intending this to be a treatise on intellectual property. I wanted to allow the audience to understand the differences and when to bring in an attorney. So question is, I get asked that, do we need an attorney for trademarks? And my answer is probably yes. I recommend it. Now, unlike copyrights where most of the people do it right, I would say a little more than half, maybe 60, 70% who file a trademark don't do it right. And then they have to go to an attorney. So I do think it's worth the time and effort to get an attorney for a trademark. Have I seen non-attorneys successfully do it? Yes, but more often than not, no. So I guess the answer is it depends, but I do not recommend you do a trademark without an attorney. So there's all sorts of international treaties covering trademarks. The most important is the Madrid system, and it's a one-stop for registering and managing trademarks worldwide. Very powerful. You file one application in one language, and you pay one set of fees to protect it in 97 members. So if you want to go international, and I highly recommend it. Now you have 6 months from filing a U.S. trademark in order to go into the Madrid and claim priority. So that's something to keep in mind. Now, also there's the Hague system, and this is actually very valuable if you have multiple iterations of designs, such as, you want to protect a logo where there's maybe 20, 30 variations. Maybe you want to file a protection on the trade dress or how the packaging, and maybe you have 80, 100 variations. So you can include those all in one application, where design patent or trademark, you have to provide one sample. It's a system for international registration of industrial designs. Again, those are designs used in industry, but don't cover the ornamental, but not the functionality. It allows you to register up to 100 designs in over 65 countries in one application. So that would be the solution if you're planning to have multiple design changes. Now, another one is the Paris Convention, and this falls into the Madrid and Hague, where if for both patents and trademarks, you have 6 months from filing a trademark. So typically you'd have your attorney file in the US, and then if you wanted to claim priority, you'd have to file it either in Madrid or individual countries within 6 months. If you don't miss it, you can still file, but you miss the priority of getting the US. And 12 months for patents. Now, one of the things with trademarks is, if you're selling a product worldwide, trademarks are almost universally enforceable, much more so than patents, unless you have a very corrupt judiciary. Now, in China, trademarks are very valuable. And the reason being is the way China thinks is China actually believes in protecting the consumer. So if there's a name of a product that's associated with a certain quality, the Chinese believe in protecting it very
Here's
much.
Gary,
So.
if you want to listen to him for a few minutes. I'm going to open up the, oh yeah,
I'm making.
What's
no,
that?
it's way too early.
Okay. Someone needs to mute it. So, okay. So, in that situation, a trademark is very valuable because in China, but one of the things you need to be aware of is that some people in China are actually filing trademarks on valuable products in the U.S. in the anticipation that's going to go into China, and that creates a whole host of problems. Okay, I see one question on the chat. If it's, will the slides be available? Yes, I'll make the slides available. Just shoot me an email and I'll be happy to send whoever needs the slides. Okay, next is, so this I took from a lawyerline.com presentation. It's actually a very good way to distinguish between design patents, copyrights, and trademarks. So let's review it very quickly. We went over all these points. Design patent covers the ornamental designs of a functional item, but the ornamental design cannot be functional. It's like the way a chair is designed, the curves, but not pipes in a device that are put there for a reason. It has 15 years. It's very important. Design patents give you 15 years versus a utility patent, which covers the invention, which is 20 years. The rights vest only once the patent issues. And what is infringement? Is it close enough? It's the ordinary observer. So what happens is the judge or the jury looks at the design patent and the potentially infringing device. If the ordinary observer would think they're the same, then you're infringing. So I gave the example of the Apple iPhone and the Samsung, which the courts held that Samsung was infringing upon Apple's design patent. Okay, so what is a copyright? It's original creative expression, and it's separate from any type of utility. Typically, it's the life of the offer plus 70 years. There are some exceptions that are life of the offer for 95 or 120 years. Those are rare. It's automatic, but registration gives you certain rights as far as suing in court. What infringe? Any unauthorized copying of it, and we'll give some fair use, which is a non-commercial use of it, typically non-commercial use that doesn't cause any harm to the copyright holder. Trademark, it's a product that configures and identifies the source of goods or services. We mentioned trade name, service marks, logos. Those are all forms of trademarks. And then you have the non-traditional ones, which is a sound, a smell, a color, could be associated. The duration is unlimited. So long as you use it in commerce and you renew the registrations, trademark will last forever. All you have to do is establish a meaning in the marketplace by selling it, and you have trademark rights. Again, you have to register it to enforce it, have a lot of the enforcement options. And then what is the infringement? It's the likelihood of confusion to goods or services. So would a consumer confuse if a similar name, your product or service with that similar name? If so, that's an infringement. So what is a trade secret? So trade secret is a information that you keep secret from the public. So it's a formula, it's a practice, it's a process, a design, an instrument, it's a pattern, it's commercial method, could be compilation of information, databases, which is not generally known or reasonably ascertained by others. So if everyone knows how to do a process or everyone knows the information, then generally it can't be a trade secret, in which a business obtains economic advantage over competitors or customers. So one of the things that you can think about is when you come up with an invention. should I keep it, should I patent it or should I keep it a trade secret? Once you're patent it, it generally cannot be a trade secret. However, as more and more abstract items become unpatentable, such as software uh, or algorithms, maybe if it's purely abstract, you keep it a trade secret. If it's not patentable, then you should keep it a trade secret. Versus a patent, which is a disclosure but gives you a government to enforce monopoly. So what typically a trade secret would be confidential information. So information that you mark confidential, that you only share with people if they sign an NDA, which by the way, more and more people are refusing to sign NDAs. I generally advise people to avoid it because it creates an obligation to you. So be very careful when accepting other people's confidential information. Could also be classified information such as government secrets, such as military secrets, which have received a classification. So in order to protect it, you must have a good internal and external process in place. People who work for the company or know it must know it's a trade secret. They must know they have to keep it secret. And also you have to external processes. You don't disclose it to anyone, and if you do, you make sure there's adequate protections in NDA. Now, one of the things to be aware of is if you disclose it to hundreds of people, even if they have an NDA, that could potentially loosen the trade secret because so many people know about it over time, it can get out there. So even with an NDA, you want to be knowledgeable. Now, you don't want to be too secretive of it, particularly if you're a startup, that you're not telling people what you're doing so no one's going to buy your product. So in that situation, you might want to go a patent if you need to disclose information, because once it's patented, it's in the public domain, you're protected, and then you can disclose it more freely. So internal, you must have the management of data policies. So generally an employment agreement to keep the information confidential. I know in certain corporations, they say all information, unless you get management approval to dispose of it, is considered a trade secret. And you generally have to label it so that people know. So if it gets inadvertently out there, or people in-house know what's kept as a trade secret. I mentioned the external, which are the confidentiality agreements or the NDA. So one of the big problems with the trade secret, once it's disclosed to the public, the trade secret is generally lost. So if there's an inadvertent disclosure or someone hacks in and discloses it publicly, that could be a loss of trade secret. So that's a risk you have to be aware of. Now, what is the most famous trade secret in the world? Coca-Cola recipe. Only 2 people know it in the company, and they are sworn to secrecy. And everyone recognizes that as one of the most valuable trade secrets in the world. If you have a way of doing business internally that could make things go faster, that could be kept as a trade secret. Now, they're both strong civil and criminal protections. Now, if you steal a trade secret, so if you leave a company and you maliciously disclose it or you hack into it, there's criminal prosecution for that, as well as strong civil. So people know that theft of a trade secret is a serious offense. So it's something to consider. Typically, what a lot of people do is if they can patent it and they have to disclose it to the public, or they have to disclose it to the public, they file a patent on it. If they can't patent it, then it might be better to keep it as a trade secret. Others do hybrids. What they'll do is initially they'll file a patent, get the patent on the overarching technology, and as they do improvements, they'll keep the improvements as a trade secret. Both are excellent ways of having overlapping intellectual property protection. And then finally, a publication is a form of intellectual property. Now, publication is simply making the public information available to the public. In essence, you're donating it to the public domain. Examples are open source. Compact is probably the best example, where when they created the BIOS, they gave it to the world, which actually was a huge industry advance because all computers adopted that BIOS language. And because of it, it made it easier to write software code and products for it, and allowed for great forward. So not just Compact, but the entire industry benefited from that standard. Now, you can publish anonymously, or you can retain ownership through claiming authorship and keeping the copyrights. Now, why would you want to publish anonymously? Say, sometimes you're not sure whether to patent or you can't afford it. People will publish the information anonymously, so it forms defensive protection, which is the next point of all. The publication can prevent others from excluding by preventing patents covering public information. So if you don't think it's valuable enough or you can't afford it, but you're worried about someone else potentially patenting it, then sometimes publication is a good idea. So there's two forms of publication. One is where you try and publish it and get the biggest coverage, the most well-known journals, and let everyone know about it. Another way is to publish it in not so well-known journals, so that if anyone, no one really knows about it, but if anyone ever down the road decides to patent it, you can pull it out. It has marketing value. So if you publish a new technology, a new way of doing business, gives you a date, and you can get recognized as the first person to bring it to market. So you have the first mover advantage. So being the first to market gives you a lot of value. Like Red Bull was the first to go in the marketplace. So for me, when I think of energy drink, I think of Red Bull and everyone else as a imitation. So and the publications can document discoveries and other events, both we mentioned the marketing value as well as publicity, as well as preventing others from claiming it as their IP. So what are the considerations? And I guess because of the questions we discussed this, patents are costly. There's no two ways about it. You have the filing fees. Now, the U.S. filing fees aren't a lot, but you need to get an attorney. We mentioned when you need to get an attorney. I said copyrights, if you want to be venturous and can follow instructions, go ahead, do it without an attorney. Trademarks, I don't recommend it, even though I've seen some people successfully file and prosecute a trademark without a legal background. Patents, I have never seen someone successfully file a patent and without an attorney. And every time they file a patent with an attorney, they usually create problems down the road. Sometimes they can get away with filing a provisional. Hopefully they won't say anything in the provisional that will cause problems down the road. Often they do. But a non-provisional patent, I've never seen a non-patent lawyer successfully file a non-provisional patent. Usually when I get them, they're a mess. Sometimes we can fix them. Most of the times we can't. So if you're gonna file a patent, I strongly recommend you get an attorney. You get a good one. It's worth the time and expense. So if you're gonna file a patent, be prepared for a costly endeavor and a time-consuming endeavor. To write a patent correctly, you have to write the invention down in excruciating detail. It's helpful to know the prior art background. You should search it. You should probably hire an outside firm to search it. And you should also take the searches and further elaborate on what the differences are and benefits, because that will help you with the prosecution. Now, Occasionally what happens is an inventor doesn't list all the details, is we'll file the patent. I asked the inventor, are you sure all the details are in there? And the inventor said yes. And we'll file the patent. And then we'll get a prosecution, usually an office action. And typically the patent office, 99.9% of the time, will file an office action rejecting your patent application because they don't want to make it so easy to give you the monopoly rights. So they want you to convince them that your technology and what you're claiming is your technology is a patentable improvement, what's out there. So they'll typically issue an office action. And so, typically the office action is a combination of references and saying, combining these references, get what you're claiming. So what I'll do as a patent attorney is I'll take the office action, review it, provide some at least initial comments, and then send it to the inventor and ask for their feedback. And very often the inventor will say, these are the differences, and I'll look, and they're in the specification, and we'll point that out to the examiner. Look, we're different for the following reasons. Sometimes they'll tell me, it's not the same, it's different for, and they'll list 3, sometimes more, 5, 6, 7 reasons. And I'll say, is that in the patent application? And they'll say no. And I say, well, I told you to disclose everything in there. And they'll say, well, I didn't think it was important at the time. But I said to include all the details, whether or not it's important. And then they realize it. So when you're writing a patent application, be sure to include all details. Whether you think it's important or not, you don't know what's out there. You know, even if you don't think it's important, the examiner might think it's important. Very often, I see something as a major distinction between what my client is doing and what the prior art is, and the examiner doesn't agree with me. And sometimes what I think is a very minor difference, the examiner sees as a patentable difference. So you don't know. So include everything. It gives you flexibility. It gives you the ability down the road. So don't be cheap or save in trying not to give your attorney a lot of work, or don't try and save time by cutting corners. List everything. And I highly recommend the prior art landscape search, where you do a patentability and you understand what's out there, and you distinguish it. You're not required to, but it's helpful both in drafting the patent application and also in prosecution. Now, if you know about any prior art, you're required by law to disclose it to the patent office. So you sign an oath and declaration that you're the inventor, and a part of that is that you believe it. And if there's any reason to believe that you're not, if references are out there that are relevant, you have to disclose it. So even if you say, look, it's not the same, I could distinguish it. If it's close, disclose it and avoid that issue. And it also makes the patent a lot stronger, because once a reference is disclosed, there's a strong presumption that patent office considered it and got it right. So if someone tries challenging it down the road, it makes it much more difficult. So I mentioned the legal considerations. What are the market considerations? So very often we only look at things from a business standpoint or a law standpoint. As a small business or startup, we have to also look at it for market considerations. So what's the ability to exclude others? You know, is it easy to tell when someone's infringing on this technology, and easy to enforce? So is that valuable? Is that the ease of doing it? If so, then that strongly indicates you want to file a patent. What's the value of excluding others? So if this is the only way to do it and everyone's going to have to eventually do it that way, that's very valuable. If it's easy to design around, what we call design arounds, then it probably doesn't have much value, because even if you can exclude others, people could just very easily design around it. the possibility of others patenting the invention. So if everyone's working on a problem, probably want to patent it because someone else is going to come up with a very similar to same solution and might file a patent. So another consideration, the market value of pending patents or patented status. So sometimes you can't get a patent, but some of my clients like the fact that it's patent pending. So for them, it's the market value. Sometimes we file a patent with very narrow claims just so they can claim that it's patented because they want to get something allowed very quickly. And then maybe we go for more aggressive claims later, or maybe just the fact that they have a very narrow patent is good enough for them. So you need to compare the benefits, the disadvantages, the publications or trade secrets. So if you just want to prevent someone from patenting out from you, then maybe publication's the way to go. If you can't get a patent on it, or you can't afford it, maybe trade secrets the way. You also have to look at the enforcement costs and the infringement value. So if it's very difficult to enforce, hard to know if someone's practicing the invention, then maybe don't do it. If it's one of many ways of doing something, again, the patent's not valuable because if you enforce it, people are just going to go back to the ways of doing it. So these are all market considerations before you spend a lot of time and thousands of dollars on a patent. So we will say we're going to go into international patents. So the most important document in international patents is the Patent Cooperation Treaty. It's a treaty, I think at the 148 countries are involved that have signed on to that. I think the number has gone up actually. It provides initial patent protection for invention simultaneously in all the countries that signed on to it. And basically any country that you probably want to file has signed on to the PCT. So what happens, you do initial filing. It has very strict standards, very similar to US non-provisional. You have to make sure that you meet those standards. And in order to, because it does get examined to make sure that the drawings are formal, it's in the right format, right font, right size, you have the right number of claims, it's claimed right, and it later gets examined. So the PTC will then search and examine the patent application. One thing is they do not issue a patent. What they do is they issue first a search report and then a patentability report recommending whether the patent is patentable or has patent subject matter or not. Now, some countries will rubber stamp a decision of the PCT. Some give it great value. Others don't even look at it. But if you have a favorable patentability, that's a very good sign as far as getting patents in other countries. They subject it to an international search. I said a written opinion, that's on the patentability. And you can choose the international searching authority. So you could choose the US or you could choose the EPO. Now, if you wanted to eventually go to the EPO. The good thing about choosing the EPO is if you choose the European Patent Office as a searching authority, the European Patent Office will typically rubber stamp the search when you go into the EPO. So that's very valuable. So a lot of my clients, they'll file both a US patent application, which gets searched in the US, and in the PCT, they'll do EPO, which is a little bit more expensive than the US, but it makes prosecution in the EPO easier down the road. So some of the considerations, like any patent application, if it's not withdrawn, it's published by the International Bureau together with the International Search Report. Now in the US, you could choose non-publication. The PCT, it has to be published. So before the expiration of 19 months from, you have the option to request a supplemental international searching authority. So you can choose an additional searching authority. You can actually prosecute it, do something similar to prosecution in the US. You can argue with the opinion, or you can amend the claims and before they get the final opinion, so that you can get a favorable. So if you don't like the opinion and you think it's wrong, you can argue with it, or you can amend the claims. And a lot of times, if your arguments or amendments are good, even though the initial opinion is not favorable, the actual opinion gets published is. And you have the strict time limits. So the international. So generally it's 30 or 31 months from the priority document, which could be a provisional or non-provisional. So again, what are the considerations of going international? Very, very expensive. So foreign filing, you know, in the US, it could be thousands or tens of thousands to file a US patent. If you go internationally, it's generally going to be in the tens of thousands, can even run into hundreds of thousands. For most small businesses, and particularly startups, it's something you can't afford. However, you know, if you do need to go international, I suggest you do it in a small number of jurisdictions, maybe the EPO, maybe a few English-speaking jurisdictions, so you avoid translation fees. You have to consider the scope of the patent and prior art. If it's a pioneering patent, yeah, maybe you want to go internationally. If it's just a small incremental improvement, unless you have a lot of money or it's very valuable, I think you should think twice about going internationally. And also the value of the patented product, both now and the future. So what are the things we look at when we're going international? The gross national product of each country. So the stronger economically the country is, the more valuable it is. So if you go US and EPO and maybe Canada, Australia, Singapore, India, and China, in a handful of countries, you got the overwhelming majority of the gross national product. You need to look at the cost to file and maintain patents. So some patent jurisdictions are cheap. Canada is relatively inexpensive. India is relatively inexpensive. Europe is very expensive. China is very expensive. The business and competitor activity in a jurisdiction. So if you have lots of business and competitors, probably want to file in that jurisdiction. If not, maybe think twice. Mentioned enforceability. So you look at the judiciary and the corruption for each jurisdiction. If it's a country that's known to have a corrupt judiciary system, you probably don't want to file a patent, because if you bring a patent infringement against a local company, all that's going to happen is the judge that's hearing the case is going to get a very nice new shiny Mercedes or other consideration. You look at the geographic and regional trade considerations. A lot of times companies go into regions and have regional sales office. So in that situation, what you could do is you could file in one country in Europe or one key country in the region and block the regional sales. So that might be a way to provide protection without filing in each country. And then again, the ability to detect and prevent infringement. If it's easy to know if someone's infringing, you might want to be aggressive. Now, we mentioned as far as patenting that there's quite a bit of time involved. So I did this slide to give you some timelines. So initially, you have your discovery, the date of invention. It used to be that people would call them poor man inventions, where you write down an invention disclosure statement in great detail and mail it to yourself and have a trademark, and that would be your proof of invention. That provided some level of protection when the US and other countries were a first to invent system. we've changed and pretty much, and the entire world has changed. The US and the rest of the world is now a first to file. So it doesn't matter who invents it, it's who's the first one to file it at the patent office. So these poor man inventions, patents of writing down a disclosure, or signing and dating, or mailing to yourself, really today have very little value. So you wanted the next stage, document the idea, write it down, even though, so you know what the invention is, and when you can hire or engage an attorney, you have a written document of it. You probably want to do a search, a study, understand what's out there, what's the alternatives, and figure out why you're different, if you're different. If you're not different, then maybe that's the end of the process. That should be the end of the process. Maybe you wanted to improve on it, so you do create those differences. That typically takes 1 week. It could take longer depending on what you need. Okay, you want to then contact, once you have a disclosure statement, retain a patent attorney. If you have a good one, it could take a week for talk to the attorney, get an engagement agreement, and start working. If you need to interview a bunch, get comfortable, it could take several weeks. Then typically the best thing, although sometimes people have to cut corners, is to search the prior art. I like to send it out to an independent searcher. I have a patent agent, patent engineer that I work with, or we can send it out to firms and they issue a formal report, and that could take anywhere from 1 to 4 weeks. You could get it much quicker in a day or two, but a lot of these searchers will charge an expedited fee, typically double or at least $100, sometimes double. And these searches could run from anywhere from $250. Some Indian searches do it really cheaply. Wouldn't recommend it. Typically $400 to $1,000. Then draft the application. Takes 1 to 8 weeks, depending on the complexity. And again, to have an attorney do it right is at least several $1,000s. Could go up to 10 or more, depending on the complexity. Okay, so the attorney drafts it. You have to file it. So your choice is to file provisional versus non-provisional. I like to, even if it's in a great form and meets the requirements non-provisional, I like to file provisional because you get your patent pending status. It doesn't count against your 20-year term, and it gives you a year to bring it to market, determine the value, and any improvements can be incorporated into the non-provisional. And it'll take an attorney a couple hours to prepare the paperwork and to file it. So I put that as 1 day. Further develop the idea and bring it to market. Once it's filed, a big mistake is a lot of people say, well, I'm not going to take it to market until I get a patent. Please don't do that. A patent is only as valuable as the product itself in the marketplace. So once you file a patent, go ahead and take it to market. Try and sell it. Figure it out if it has value in the marketplace. Because if it doesn't, probably want to stop the patent. And if it does, then you know to be aggressive with the patent filing. Don't wait for the patent to be issued. Once you have patent pending, it's off to the races. Get it to market. Figure out what the minimum amount you have to do to the customer and start selling it. Talk to people, sell it. And that's how you make money, not on the patent. So patents are very valuable, but they're very valuable in protecting other people from copying it. If no one's using it, then a patent is worthless. Again, we call it paper patent. So you further develop the idea, you bring it to market. It's variable. You have the 1 year from the provisional to update it before you file non-provisional. Once you file non-provisional, if it's a significant improvement or development, you'll have to file another one. Then you file PCT national or non-provisional. Again, the Paris Convention, you have 1 year to claim priority. So if you file US provisional or non-provisional, you have 1 year from that date to file a PCT or a national application. Now, sometimes what we do is we'll have a very rough provisional. We'll file that just to get something on file. Then over time, the inventor is improving the invention. We'll file a non-provisional in the US, claiming priority back to the provisional. Now, we can either go PCT on the provisional, or we can wait a year, assuming there's a significant amount of improvement, and then file it off of the non-provisional. Now, we will lose the priority date of the provisional, but generally that's not a problem, and it delays the costs and allows you further improvements. So the publication, so approximately 1 year after the patent application is filed for non-provisional, 18 months for a provisional. If you go non-provisional, the application is published. And then you get, if all goes well, your patent attorney does a good job, convinces the patent office that it's patentable, you can get it issued 1 to 5 years after filing. The international issuance will take up to 2 to 10 years. Again, you're looking at a long drawn out process, not cheap, not easy, and takes some time. So another thing is dual use technology is becoming more and more important. And what is dual use technology? Is any technology which can satisfy more than one goal or could be used in multiple applications at any given time. So examples for the oil and gas industry, sensing and imaging technology. Very often the seismic, the sound waves, have military applications. They could be used for sonar. I once filed a seismic application and we got hit with a military review, probably because the processing we were using was very similar to what the military was processing for, sonar for subs and ships. Sensing and imaging technology. So in the oil and gas industry, we send a sound wave to the subsurface to image it and give us an understanding what's underneath. And in the medical profession, they typically send an ultrasound wave, very similar to a seismic wave, through the body to get a very resolution. Again, this could be an invention in oil and gas, could be used in the medical field. In fact, when I was starting out, we were moving, this was over 20 years ago, from three-dimensional seismic imaging, which was invented in the 70s, 80s, to four-dimensional, which came out in the 90s. And I was following some patent applications on it. And I looked, and there was some prior art on four-dimensional for oil and gas, and there was no prior art for imaging of medical. So I tried to convince the powers to be to file four-dimensional, which is time-lapsed imaging for the medical profession, because I couldn't find anything. And it was quite clear that over time, eventually, the medical industry, so we decided not to file it. Eventually, I saw GE came out several years later with four-dimensional ultrasonic and other forms of imaging, so the medical professions could understand the development of medical issues over time. Now, if we would have filed that, we probably would have, over the next 20 years, gotten licensing royalties for every time someone in the medical industry did a image on that in 4 dimensions, which you can imagine probably would have been more valuable than the 4D in the oil and gas. So you always have to look at technology in multiple industries. So computer processing, high tech, we processing a lot of data from the well, high tech now with artificial intelligence is a lot of technology out there, how to improve the computer processing. So membrane, hydrocarbon separation, oil field's been using membranes to separate different types of hydrocarbon and contaminants. Well, it's very valuable in water purification. That's what I'm doing in filtering. So the membranes that were developed for oil and gas can also be used for water purification. automation, real-time control. So I had a client that did automation for drilling rigs. Now, obviously, there's multiple industrial applications for that. So each one of them can provide additional value. Pipeline sensors. So industry in the 90s started putting sensors on pipelines. Well, others got very similar patents on using that to detect remotely how much oil or gas was in a pipeline or a tank. And that data became very valuable for commodity traders. So very often when you come up with new technology, you have to consider, are there other applications for that are outside of it? And you might want to file multiple patents on that. So considerations of patents. Unintended use is a defense against obviousness. So if you get using it in an unintended way, that's a way to get patented. So if you reverse the process or you manipulate it in such a way that the original operators have recommended against, and you're getting better results, we call that improved data. You should disclose that data. You should disclose it because that's a way to argue around an obviousness rejection. We mentioned the dual use. The value of an idea might not be so valuable in one industry, but can be very valuable in other industries. And the fact is that technology in one industry maybe wasn't considered in other industries. Most of us have an oil and gas background, being from Houston. We all know oil and gas is in tough times. People are getting laid off on a very scary level. The down cycles have become more often and much more violent and destructive, and the market has become much more variable. So a lot of us are going to have to look into other industries. So a lot of the technology that we have might be more valuable for other industries than it is for others. And then also increase your marketability in other industries. So anytime you have skill sets that are valuable in multiple industries, that's very good to have. So I'll be happy to answer questions. I see there's a bunch of questions in the chat. So I guess I'll go to that and then we'll start answering this.
Gary,
Yes?
we have Alex who has been chosen to pick up the questions that have not been answered by you, and he will pose them to you and then you will answer them. Is that okay with you that way?
Okay, Alex, you want to just read the questions and I'll do my best to answer?
Okay. And besides those that have been posted, there could be other follow-up questions as well. I have a lot of questions, I believe, but I just waited. Yeah, Alex, go ahead, please. Alex, are you there?
I can handle the questions.
Okay, Alex may have left. He said he would not be able to get to the very end, maybe. Yeah, okay, then you go ahead, Francisco.
Okay, I think you answered most of the questions in the list, but the ones you have not, it's a suggestion. Since you said that you will make the PowerPoint available to us if we communicate with you, can you put your email in your next slide so I can capture that?
Yeah, let me give my email.
And
there it is.
That awesome. Let me take that picture right there.
Okay, take that picture, and there's multiple ways you can communicate with me. So that's my email. You can send me a message on Facebook or LinkedIn. I think is a very good way to communicate too.
Awesome. Hold on 1 second. 17. Okay, so now we can make that available. Perfect. Thank you.
Okay.
So sorry.
Quick question, I guess, before I lose everyone. uh, thumbs up or thumbs down, or was the level of detail good for an introduction? Should I provide more detail or less detail? Because this could be a semester-long course, or I could probably make it into a 30-minute lecture.
Well, let me add, are you referring to Mr. Claudio Gutierrez's first comment?
Yes, I'm just saying overall for an introduction, did I provide a good level of detail, too much or too little?
Let me address that. Number
Yes.
one, that gentleman didn't know what he was talking about because Salim corrected him. It wasn't 30-minute introduction that was done, but pay it forward, Carlos Pineda. And that was a 15 minutes introduction, not a 30 minutes. So he really said too much.
Yeah, because
And I wish you would have stayed because you had a very good presentation. There is no, and from my perspective, there is nothing wrong with your presentation. It's just perfect. And you will see by the amount of questions that you're gonna get right now.
Okay,
Besides
awesome.
that, the ones that you already got.
So I'll take it.
I think, Gary, it was not short. I think it was good size. Yeah, this topic is really a very extensive topic, and there are a lot of issues. And I think you tried to cover highlighted most of it in a very concise form. But
Gary, in a nutshell, keep your presentation that way. Obviously, there is you can learn from the questions that have already been asked to add to it without making it so long. I do not think it was too short, too long. It just repeating what Salim just said. This can be a very extensive topic. So yes, thank you for that.
Okay,
So,
awesome.
So the questions, the last questions that you answered, just to be sure that you did answer, it came from, let's see, from Alex Mendez. Is it, what happens to the old logos when logos are updated? And I think you answered that question already.
Yes. So yeah, and trademarks are generally considered use it or lose it. So you have to keep the trademark in commerce. If you do not consistently use the trademark over time, you'll eventually lose the trademark.
Okay.
What is the time frame when you say you lose it? What is the time frame? Is there any strict time frame?
It really depends. So if over time, over years, you to stop using it, then that would be considered a break. Do you have to show the trademark every second of the day? Probably not. So that's actually a fact question, and that became an issue in a very long series of cases. If you want to read the considerations, I guess the case to study would be Kellogg's versus Exxon on Tony the Tiger versus the Tiger for ExxonMobil, and pretty much the issue dealt with was, did Kellogg's abandon the trademark by not using it over a period of time?
Interesting.
So, there's no easy answer. And to give you the main consideration, it's what would cause confusion in the marketplace. So the real answer would be, did you stop using it long enough that the marketplace stopped associating that mark with your goods and services?
Okay.
Okay. Now, before I continue with the questions, I really would like to take this opportunity to take a picture of the whole group. Okay. And if you don't mind, I will tell who is out of line. So he looks handsome. So how about everybody coming in with and show your beautiful face. Okay, so whoever cannot. David Daughtery, I think he left. Oh, here is Alex. Did you go to the football game, Alex?
No, I had to step away and check on my kids here. Sorry.
Okay. Okay, so Eric and Banzer. All right, everybody. If you, Salim, if you can show if you can grow a little bit more so I can take that picture and you look good. That is perfect. All right, so let me take that picture and see. All right. Let's see. Here we go. Now, perfect. Now you can escape if you want to, but I got you now. So we can go back to our picture, to our questions. Alex, I don't know if you want to take over with the questions.
No, it's fine. You can continue. Thank you.
Thank you. So the next from Gregory Devenish, he said, say I have to go to another meeting. He said, greatly appreciate the Pay It Forward folks for doing these seminars. So he's good with us doing this thing. David also, Daughtery asked, will the slides be available for future review and reference? Yes, they will. As we said, Gary will send you the presentation once you get in touch with him to his email or via LinkedIn. However, the presentation has been recorded and it will be in YouTube also. So, I had a question. If I patent something, when I start commercializing it, do I need to give the patent number?
Yes, it's best to give the patent number, and at the very least, you should let people know it's patented. And the reason being is that you want to put people on notice about that. And I didn't go into it because this could be a several hour or day discussion is on enforcing a patent. Now, if the patent is infringement is willful, the courts will issue treble damages, which is 3 times the economic damages. So typically you want everyone to know about your patent, and by letting the entire industry know, by putting notice on it so that people can't say it was unintentional. And if someone is infringing upon it, you want to immediately notify them so that typically with a letter, very strongly written letter from a lawyer, putting them on notice about your patent so that if they continue, they can't say that it was unintended and it's obvious that the continued infringement was willful.
Okay. The next question, actually comment that came from David. He also is very appreciative that the Pay It Forward people are putting these kind of webinars together for people to know more and help each other. Let's see. Doug Lear, he made a comment here. He said maybe he wants to expand after I read it. Level of detail was appropriate. Doug?
Yeah, Francisco, that's just a very quick response to Gary's question about was the level of detail appropriate? Was there enough content? Should it be expanded? Should it be streamlined? I thought it was great. I have been an inventor on a lot of patents in my life, and I think that what Gary provided us was a great overview.
Yeah, and that's what I wanted to do is, if anyone goes into a startup or a small business, I want them to at least understand the basics and know when to, what are the considerations on how to form an intellectual property strategy, so they know when, at least when to ask the questions or maybe when to talk to an attorney.
Mhm.
And here goes another one. David Daugherty says, enjoy the information shared. More detail is always welcome. There you go, Gary. You're coming strong.
Okay.
Uh, Carlos added the link. Cap, would you please expand on that link, Cap?
I just added that. I'll be looking for this presentation and the YouTube link. That link will lead you to all of the presentations so far shared by Pay It Forward Networking Program participants.
Thank you. Salim, how much time do we have so we can open now to verbal questions?
Well, we have time.
Okay, so
An hour. Have you finished putting out all the questions from the chat?
yeah, we finished with the questions in the list. So now
I
it's
think there was
open.
one other,
Well, I have a number of questions to Gary. Gary,
yes, go ahead.
if you can answer them, please. I understand the patent is a federal, under the federal jurisdictions, right? Patenting, submission of
Yeah.
the patent and the approval.
Yes.
And for that, I mean, is there the patent office in Washington, D.C., where if someone such as me wants to work for the patent, and in that case, do I have to go to Washington, D.C. and stay there for a year or so before I come back and work from Houston office?
So it used to be that almost all the examiners live in Washington, D.C. or commuting distance of Washington, D.C.
Mhm.
Not anymore.
Oh.
In fact,
Because of the pandemic?
not because of the pandemic. In fact, maybe more so because of the pandemic.
Mhm.
But when the patent office in 2000, a little after 2000,
Mhm.
moved to their new location in Alexandria,
Mhm.
they didn't build it big enough for all the examiners to stay there. So they created a process of telecommuting before telecommuting was even popular. So the patent office, I guess, being an innovative federal agency, decided to be innovative. And 20 years ago, they were encouraging examiners working remotely. And they actually call it, I don't know if they still call it, but it used to be called hoteling, where the patent office, the patent examiners would work anywhere in the US and they would log into the system, work remotely,
Mhm.
and they would show up every so often in Washington, D.C. to meet with their supervisor and also be available for in-person interviews. And some people would like to interview the inventor would like to, or the attorney would like to interview the examiner face to face. So they called it hoteling, both because they have to get a hotel in DC, as well as they would call the temporary rooms in the patent office that they would give as offices, hotels. So it became popularly known as hoteling,
Mhm.
and they went even further. They even created regional patent offices. The closest one would be in Dallas, where you can actually go there and use the computers, the same computers that the patent office uses for searching. So if you go to DC, you can register and you can get on the same computer and the software that the examiners use to search for prior art. Now, they don't make it available remotely. You actually have to go to either the Washington D.C. or one of the regional patent offices. And the closest one would be Dallas. So if you don't want to, if you want to meet the examiner, a lot of times you can arrange to meet them at one of the regional offices too. So I didn't mention this during the presentation,
Mhm.
but it's very valuable to interview. I used to fly down when I was with Exxon all the time to meet face to face with the examiners. And that was extremely valuable for getting a patent issued. Now, because of costs and probably because of COVID, it's easier just to get on the phone and call them and speak with them, because very, very rarely do two people understand technology the same way.
Yes, that's right.
Everyone looks at technology difference. The inventor, based on the company, their educational background, what they've done in the past. Some people look at differences as significant, and some people look at the same difference as insignificant or not important. So when you meet them face to face or talk to them, you can begin to understand their thinking on why they're rejecting a patent. And very often when I get a rejection, I read through it and I'm trying to figure out, or understand them. What I think the examiner is saying in the rejection is very different than after I've talked to the examiner. And, knowing exactly how the examiner thinks makes it a lot easier to prosecute and get that patent allowed. And, sometimes the examiners are wrong. Sometimes it's just a difference of opinion. But obviously, the more you can understand what the governmental agency, or in this situation, what the particular person is thinking, that makes it a lot easier to get the patent. And you know what?
Yep.
Sometimes I've gotten patents where I made an argument and I thought it was the right argument, the examiner rejected, and I made another argument, but when I understood why the examiner was rejecting it, I made another argument that was more aligned with what the examiner was thinking, and the examiner allowed it for a reason that I thought was wrong. So, who's right? Who knows? But, it doesn't matter who's right as long as you get the protection you need.
Sorry. You mentioned that attorney will have to interview examiner. Is that an attorney that is appointed by the federal authority, or is a public attorney such as you from ExxonMobil or anyone else?
So anyone can interview the examiner.
Okay.
You have to be, if you're not the inventor, you have to have power of attorney, which is a standard form that the inventors sign that gives me the power to be their attorney in front of the patent office, so I can interview those cases. But if you're the inventor or the representative and have power of attorney, you can go ahead and meet with the examiners. Now, it's very important that obviously there's a difference, that when you do it, you have to be polite, be respectful. You may not agree, but being polite and agreeable goes a long way in the prosecution. So I caution the inventors that, because very often there's an emotional attachment to their invention. They spend months, sometimes years working on this, and some guy who's probably not as knowledgeable as him or woman says it's not patentable. Very often they're wrong or they don't understand it, and they want to say basically you're stupid. And that's one of the things you can't do. You have to first understand it, and then gently, if the examiner is wrong or doesn't understand them, guide them to the right answer so they get to them themselves, because you can never force someone to accept something that they don't want. So it's more of a gentle process.
Gary, also you said that since the federal authority is the ultimate authority to approve a patent, so anything that examiners say is yes or no, approved or not approved, is not a good one and all that, does it ultimately go through a federal authority's appointed attorney as well?
Yes, so the agency is given deference. What deference means is that there's a presumption that what the agency decides is correct. However, there's a process inside the agency
Mhm.
and a process outside to challenge the agency. So say you get an examiner and he rejects it, and you call him up, you interview, maybe you meet in person, you send written arguments, and he just gets it and you feel you're wrong. There's ways to appeal it. So the easiest one way is to request an interview with the supervisor there.
Mhm.
Obviously, you don't want to do that until you exhaust all, because you know the examiner is not going to be happy, and if there's not a real reason to have the supervisor is going to think you're wasting your time.
Mhm.
You also have a pre-appeal brief where you can have it reviewed by 3 examiners inside the patent office, 3 independent, and they took a look at it. And then there's an appeal process inside the agency itself, where if you can't convince the examiner, you appeal it. And again, that goes to 3 senior levels examining agents, and they actually review your arguments, which is in the form of a legal brief, and the patent examiner's argument, and they make a decision. So if you do not like the decision from the appeal brief,
Mhm.
at that point, you can appeal to the federal courts, and you can get a judge, and basically it goes to a very high level federal court, the federal appeals for the Court of Appeals for the Federal Circuit, and then the judge will then read your appeal brief, the patent office examiner's appeal brief. You can request oral arguments. You can request oral arguments internally, and then the judge will make a decision. At that point, if you don't like the decision, the choice is to appeal to the U.S. Supreme Court, which very rarely hears court cases. So I would say 95% of the cases
Mhm.
you can get resolved with the examiner. Maybe 4% you have to file an appeal brief, and then maybe 1% you'll have to take to the Federal Circuit in a actual lawsuit against the patent office. So that's how it goes. So yes, the courts will give deference to the patent office,
Mhm.
but if you can provide evidence that the patent office is wrong, you can get the patent office overturned by a federal court.
You see. Gary, are you also a federal, patent litigation attorney?
I have done patent litigations in the past when I was in a law firm. I'm not doing that right now.
Okay.
So generally, there's 2 types of patent attorneys, what we call patent prosecution attorneys and patent litigators. Sometimes you have overlap. For a while, I did some overlap work, but most of my practice and all my practice right now is patent prosecution, preparation and prosecution. Now, if you want to go with a litigator, a lot of times what I'll do is I'll work with a litigator and provide the patent background, and then the litigator files the forms and argues it in front of the federal judge. So technically I could, but I've decided to practice this, and I joke I have 2 full-time jobs. I have the intellectual property practice,
Mhm. Mhm.
and I have the patent startup. So the technology startup. So I got my plate full as it is. So
So
right now I'm purely
as,
focused.
as a follow-up to that, we cannot go wrong by going to Gary.
No.
That's one of the difficult things. Which lawyer do I pick? Now, we know Gary, and Gary will guide us the right way.
Well, he has
Yes,
extensive experience of 20 years. Yeah.
Yeah, and I think what makes me unique is certain people have 20 years in-house counsel.
Mhm.
You get a certain perspective. I can guarantee the
Mhm.
perspective of a patent attorney at Exxon or Shell is very different from a patent attorney at the law firm, which cares more about billing. You know, at a big corporation, their number one priority is freedom to operate. At a law firm, the number one priority is billing and prestige. They want to be have a lot of billable hours and be prestiged as the best. So everything has to be perfect and generally cost. The small firms are a little bit more cost sensitive, and then the solo practitioners are very cost sensitive because they have clients that are either very small businesses or independent, and you know, every dollar counts. So, you know, I understand it from the perspective. You know, I understand a small business, and I understand the startup. You know, what's the difference between a startup and a small business? Small business has a sustainable business models in the marketplace. A startup is a new entity that's in search of a sustainable business model. So you have a technology or an idea or a new product, and you're not yet selling it, or you're not yet selling it profitably. So you have to pivot and either find the customers or pivot over time to get there. So, you know, I understand probably the different perspectives. So whether you come to me as an independent inventor or as a team member of a startup or a small business, a mid-size, or one of the largest corporations in the world, I, 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 I probably been there and know what the expectations are.
Okay.
Salim, you still have any questions? Because we got another.
I have another question. Is
But
that
what-
Carlos?
what-
You want to say something?
Yes, why don't we alternate? Other people may have questions. I'm sure
yeah.
Salim may have a slew of questions. I have a couple, and I'll
Okay.
ask one right now, maybe a comment.
Okay, go ahead, Cap. Who will be next after Carlos?
Doesn't matter.
Because at the end I'll have about 3 questions too.
So, yeah. So you did mention, and just as a follow-up, a comment to what's been said in the last minute or so, you know, that you need to look for somebody who's capable to a good lawyer, a good person that's going to cover everything. But you did also mention the fact that the person, the inventor, has to give enough detail. You know, I would expect that the lawyer also is going to guide the inventor with questions in order to give the proper details. And it's kind of like going to the doctor and saying, and how do you feel? I feel good, but but you do have headaches. And you don't mention those things. You know, you have a backache and you don't mention those things. You know, so the doctor also has to be good enough to also ask questions at the same time as that the inventor has to come up with all the details. You know, as you were saying those and repeated a few times, my question was, okay, how do I find the good person to go to and to work with, you know, for the IP, for the patent? And now I know Gary, yes, but if I did not know Gary, what is your suggestion on what to look for?
So a couple of things is technology is very important. You know, you want a patent attorney that's knowledgeable in that technology area. So most of my patents have been in the oil and gas mechanical. I do some consumer products, but frankly, I've also done some electrical, and I even recently did a pharmaceutical patent. Now, in that situation, I had a client that was desperate to get something very quickly, and said basically, and I warned him and I said, look, I could do it, but this isn't my specialty. And we worked together, and I think we got him a very good pharmaceutical patent. But it was a startup. He probably couldn't afford to go to a major law firm. But probably in that situation, if money was not an issue and time was not an issue, they would have been better off going to an attorney that had decades of pharmaceutical patents, behind them. Although I feel very confident that we're going to do very well with that, but that's a consideration you look into. You ask the attorney, how long you've been doing this? Have you dealt with clients in my situation? A startup versus a corporation, a large corporation, where one is going to be very sensitive to cost. Have you worked in this technology area? A computer type of hardware patent is very different than say a chemical patent so those are all areas to consider. So it's very important that you feel comfortable with your attorney. Recognize that it's a commitment. It's a commitment in time and money. So you're going to have good rapport. You're going to have to trust the attorney. You're going to have to be willing to talk to the attorney and give all the detail. If for whatever reason you're not comfortable disclosing everything about the invention, then maybe you shouldn't talk to the attorney. Also conflicts are important. For example, we're doing a thermal distillation technology for our startup. If you have a competing thermal distillation technology, you probably don't want to talk to me.
Gary, what is the background that is required for a patent examiner? Can you shed a little bit on it? And where is the patent office that you have to contact to be an examiner?
So typically, in order to be a patent examiner, you have to have a science or technical degree. Mm-hmm. I do know they prefer it, that they do like industry experience, and they do like advanced degrees. Mm-hmm. If you go to the U.S. Patent and Trademark Office, you can apply online. Mm-hmm. They list the position. I think they list the position. I'm pretty sure they do. And you probably want to apply to the art unit that matches your technical degree or your background. Mm-hmm. And basically submit a resume. Here's a hack as far as improving your chances of getting it. Is if you know anyone on the inside. Mm-hmm. So if you know a attorney, that's worked in that art unit before, mm-hmm. maybe contact that attorney and see if he's worked with those examiners before, and see if particularly the supervisor examiner, and see maybe they could call up and throw out your name, because typically the way you apply is you submit a resume online, and we all know that it's very hard to distinguish when you have scores of resumes you're looking at. So anytime the supervisor or someone on the inside can put in a word, that puts your resume at a higher level. So I would say if you want to, mm-hmm. I would Google U.S. Patent Office patent job openings and apply that way. Obviously having a background in patenting. Another way to do it would be to sit for the patent agent exam, which is a very, very difficult exam. In fact, I would say the patent exam is harder than, say, the Texas bar exam. It has a lower pass rate and takes months of studying of the MPEP, the Manual Patent Examining Procedures, and a lot of these rules are not rational. A lot of them you have to learn over time, and which is one of the reasons why you want an attorney who's been doing this for a while, is because many of the patent rules, prosecution rules, don't make sense. So it's not a easy route. I actually think it's a very rewarding route. I've never worked for the patent office, but I've always been on the side of prosecuting patents. I learn about technology. If the patent's a good patent, it's new technology. If not, I'm learning about the background and what's out there. So for every patent I get, it's always a learning experience. And to me, that's I love technology. So someone loves technology and is willing to spend the time learning it. I think it's a great profession. So I would highly recommend people go to the Patent and Trademark Office and see if there's jobs available. Now, even though they do allow what they call hoteling or telecommuting, I think there will be a period of time that you have to be in Washington, D.C. while you're getting trained. But once you're trained, then you can go back and you're allowed to work anywhere in the U.S. Now, in theory, you should be able to work anywhere in the world, although the Patent Office has made it very clear, and they have checks on the systems, the examiners have to be in the U.S. while working. So they do check. So if you're planning to move to another country and want to telecommute from another country, that won't work.
In Canada?
I don't believe you could work from Canada. You have to work from the U.S.
Okay. Any other questions from any other of the attendees?
Yeah, why don't you ask one of your questions and I can ask one.
Okay. One of my questions is patent pending in a patent, no, what is it? The patent pending, they give you a number, and once the patent is approved, they give you another number. How protected we are with the patent pending number?
Okay, the answer is somewhere in between. So if you have a patent application, you can't sue someone in federal court until the patent issues. However, you could put them on notice that the patent application is pending. And if the claims get allowed, you can actually get damages up until the point you filed. So it's not the same status as patented, but patent pending does give you a status that's above having nothing. Now, how likely they are to be afraid of a patent application versus a patent depends on who's doing the infringing work. Some don't want any risk whatsoever. So if they know there's a patent pending, we either get a license or not infringe. Others might be more aggressive and say, I don't think you're going to get a patent, and ignore it. So the answer is it depends. So it's somewhere, it's not a patented status where you can take someone to court and get an injunction that same day, but it's not legally nothing.
So if you got to the point of patent pending, go forward and get that lawyer to make a good letter and say, you're on notice, my friend. You're infringing on my patent pending. Is that a good?
Yes, I agree. Let them know about it. Maybe you're in a situation where, if you're confident you're going to get it, one of the risks is that they could call the examiner and provide prior art, but you know what, if they're going to challenge the patent, they could do it in court too. So I would actually prefer they challenge it in the patent office because, any information they give to the examiner is going to be of record. And then there's a presumption that the patent office considered it. And I'd rather have a technical expert at the patent office consider their arguments than a judge who probably doesn't have a technical background.
Okay.
So there might be some attorneys that have a different opinion. One of the strategies that I actually like, if you can afford it, is go in with an initial patent application, call the examiner right away, and get to an allowance, even if the claims quickly aren't as broad or as aggressive as you think you are, because then you get an issued patent, and then you can file another patent and go after more aggressive claims or a different claim set that might be more difficult. Because at that point, you have an issued patent, so you can tell the whole world it's patented. If someone infringes it, they can go ahead and you can go ahead and sue them. And you can file additional patents. Now, if they challenge that patent and are successful, you still have a pending patent application. You can address the issues that they challenged and still go after them. So I like that strategy of calling the examiner and feeling out the examiner and saying, all right, this is what we can get it as quickly as possible, and then continue it down the road and be more aggressive on the second one, on the second and third, and keep the patent application pending, because over time it changes and you might have to get different chain scopes. So obviously that's an additional expense. So that's something to consider, but that's my preferred strategy, is to get a issued patent as quickly as possible, and then get additional patents later on. But that's something that everyone has their unique needs and capabilities and I guess resources. So that's something to discuss with your patent attorney.
Okay. I have another question if nobody else have a question.
Go for it.
No, but, and just to follow up on something that you just said in Francisco's question, you did have a timeline in your presentation. So is there, what is the time from the time that you apply for the patent and you're given a number?
Why don't you go back to that slide? Go back to that slide, please, Gary, because my question is going to be around that too.
Okay, can everyone see the slide?
Yes.
Okay.
No, I think it's the other one before. The slide before that one.
That's the drafting of the application. So
you start the process, and I know it takes a good while, and now you get a number for that provisional patent, or non-provisional patent, and so you go through all of that. Is there a standard? So you say international, okay, U.S. assurance process.
Okay.
How long is it before you get the patent?
Okay, so in most situations, it's probably going to be 2 years, 2 to 4 years.
Why?
After you file, because it takes a long time. It may take a year and a half after filing a non-provisional, before you hear back from the examiner. Depends on the art unit. I could research that if you want to know. Sometimes you'll hear back from the patent office in under a year, sometimes over 2 years. It really depends on how backlog that art unit is. Used to be you could call the examiner and the examiner could take cases if you asked to, could take cases out of order. They can't anymore. Now, most of my clients don't need a patent issued right away. In fact, it's to their advantage to file and not do anything because every dollar counts, and paying me or another attorney to call the examiner and convince the examiner, if they don't need the patent because no one's infringing upon it, push off that cost as far as possible. And I see this over and over again, whether you work with me or another one, get your product to market, develop it, to file your patent application, get it to market. Sometimes I can't convince people, oh, I can't do anything about it. I can't talk to people because it's not patented. I don't think any patent attorney will give you that advice. It's filed, it's patent pending. Start selling it. Take it to market. A patent is only, and I'm a big believer in the value of patents, a patent is only as valuable as that product is in the marketplace. If you're afraid to talk to anyone or sell it to anyone until you get a patent, it's going to take years before you have any value to that patent, and it may not be, and then you paid all that money to a patent attorney. I would rather my clients file the patent application, spend the next year taking it to market and determining whether or not that technology has any value. And then, if it has value, then file all additional patents, then tell me to rush the patent through the patent office. But really, they should take it to market, develop the value, and you know what? Sometimes we're wrong. Sometimes we're too early. Sometimes the technology doesn't have any value. Until you take it to the marketplace, you're not going to know that for sure. Take it to the marketplace, and if it's not valuable and you're talking to hundreds of people and everyone tells you they're not interested in it, either you're too early, it doesn't have any value, you either have to abandon the idea or maybe you pivot. Pivots are okay. Pivots are when you say, look, my initial view didn't have value in the marketplace. Let me change the technology. Let me change the application to something after talking to 100 people I know is bothering them. So, a lot of times I went to the NSF I-Corps program, which follows the lean startup model. I highly recommend anyone take that course if you want to do a technology startup. And what it does is it tells you to talk to people, not about your technology, about their problems, because they're only going to pay for your technology, whether it's a good or service, if it addresses their problem to the point where they're willing to pay you. And most people would rather have the cash in their hands than give it to someone else. So it better be a pretty severe problem that they have, a valuable problem that they want to address, or else they're not going to pay you any money for your goods or products. That's just the way people are. It could be the best invention in the world. So you have to understand your customer's problem. And if your product, invention, or service does not address a problem, either you're talking to the wrong customers, or you have to change your technology or your product, market, or service. So the only way to know that for sure is to take it to market. So a lot of people say, I want to get a patent as quickly as possible. Generally, you don't need it. Okay, say you file your patent, and then 3 months later, someone is infringing upon your patent, or you determine your patent is extremely valuable in the marketplace and your technology, and you need to get that patent issued as quickly as possible. There's ways to do it. So one way is a petition to make special. That's a large fee. Last time I checked, I think it was at least $1,000. It could be even more, in which you file this petition, you pay the fee, and it bumps you to the ahead, so you'll get examined in a couple weeks. Again, you're going to pay me a couple hours of work to file that petition. You're going to pay the fee $1,000. Now, there are some exceptions. If there's litigation or it's very important to society, like a COVID application or environmental, or you could file the petition for reduced or free. You still have to pay the attorney to file it. And then the examiner is going to hear it very quickly in a couple weeks. So you should get a response in weeks, not months or years. So that's something we could do. We can interview it much faster, but make sure that you want to spend the time and money to get it, because either someone's infringing, you need to sue them, or the product or service is very valuable, and having a patent will give you marketing vengeance. But even still, I tell a lot of my clients, if your product or service is so valuable, you don't need a patent. Sell it, get the patent later, make some money. I can get you a patent very quickly, but you're going to pay me a lot of money. You want to make money, which is selling your product or service or technology. So, as you can tell, I have a very strong opinion on this. And, so we could as a patent attorney, if you want to pay me, I could expedite it and get you a patent in a couple months. But you have to ask yourself, is it worth the time and money?
Okay.
Gary, I have a question. If two entities have submitted for patent approval on a very similar product very simultaneously, and what happens? I mean, if one precedes approval, the other one, I mean, the one who is in the rank submitted it, say 10 days earlier than the other one is going to get it, or you can fast track it. What is it? How do you do it? Handle it?
Yes, so absolutely. So it used to be a first to invent, in which we would have an interference proceeding if two identical or nearly identical patents were filed, in which you could provide evidence of invention before the date. Now we're strictly a first to file. So what the office is going to do is, if they're identical or nearly identical claims, whoever filed them first is going to get it.
I see. Okay.
So very important to get to the patent office quickly. If a lot of people are working on it.
So to answer your previous question, so get it to the market the product first, and then go for the patent. So it's really an understanding of balancing the two things, right?
Yes.
So I marketed it, on the other hand, I missed the patenting it early enough. Someone else marketed it, so he got it, right?
Yes. So what I recommend my clients do is spend the time up front, file a really good patent application, spend a couple weeks, hire a good attorney, put all your time and effort into writing a good disclosure, go back and forth with the attorney, do a search report, know what's out there, add additional detail to further distinguish your product or service from what's out there, and then file the best application you can. Once that application is filed, take it to market. Go. You've done your patent due diligence.
Yeah.
Make some money, sell. So, I look at it as very compartmentalized. Yes, before you start selling it and you hit that commercial bar, you want to file a patent. Get a high quality, good quality patent, the best patent you can filed. And then after that, let it sit in limbo for a year or two while you're selling and making money. And if you're improving it over time, then make the decision, all right, is this enough of an improvement that I need to file a second patent application on it? For example, if your initial patent maybe isn't successful and you talk to your customers and they say, they want X, Y, and Z, and you come up with an improvement that gives them X, Y, and Z, and it starts selling, you probably want to file that second patent application.
Okay, yeah.
Okay.
So as a separate patent filing.
Yes.
Okay, on the improvement of
Hey,
stuff.
May I have one last question, and I have to leave before I get in trouble. Today is our 39th anniversary, so
Oh.
Happy anniversary.
this has to do with, you know, you always see all of the old patents, you know, the draft of it. I'm assuming there's a standard form and so on, but you always see the same type of drawings. Has that changed? Can it be pictured?
No, you cannot file a picture unless you get special permission. So the patent drawings are required. You're required to provide formal drawings if necessary for the invention. Now, even on a strict process patent, what we do is we show flow charts so that doesn't become an issue. Mechanically, if it's a mechanical invention, the drawing has to show every element that's being claimed or necessary for practicing the invention. So you have to provide a lot of detail. Now, the patent drawings requirements are very strict. In fact, you know, I probably knew them very well when I studied for the patent bar exam. Over time, I've relied more and more on good drafters. I highly recommend you get a good drafter because they know the rules over time. And, you know, again, cost things. I can get a patent drafter in India to do patent sheets at $24 to $50. I have a local guy in Texas who charges me $90 a sheet. There's bigger firms that charge a lot more. I always recommend that you go with the local guy from Texas that I've been using for a number of years because he does a great job. And if there's an issue, he'll very quickly fix it for free. I had a situation where someone went to a cheap Indian firm and they got drawings and they screwed it up. And rather than fixing it, they tried to blame the inventor and me as the attorney. And I'm like, and charge us more money. I'm like, look, I don't care. First off, we weren't at fault. And second off, I don't care. Just fix it so they get approved by the patent office. Now, I can tell you, you know, even if the mistake is with me or the inventor with the local Texas attorney, he always fixes it, never charges me. So that doesn't, I'm not going to sit there and get into an argument on whose fault it was if the drawings were done wrong. So, you know, but yes, that's a good observation. The drawings all look the same because they're very strict rules on the font, how you shade it, how you label it, and that's by design.
Well,
So,
thank you very
you
much.
know,
I have to leave, and you know, you may want to put that observation in your presentation because that's many people have the thought that I can just do a simple drawing as long as it explains, you know, with the arrows and so on. But if they're strict, yeah, you may want to. I thank you very much, Gary, and I have to leave, so we'll talk to you later. Bye-bye.
I think.
Thanks, Carlos. Have a good weekend and stay safe.
Thank you. Bye-bye.
Yeah, stay safe.
So I have one last question.
Go
Go ahead.
Protection. I always carry a notebook with me and I draw my ideas. I'm a completions man. But this time, I didn't have it in my notebook. And I presented it to my company in a blackboard. Great idea, but I didn't think it took off. Until I saw a patent with my idea. My mistake is I didn't erase it from the drawable.
Now, what was the listed so-called inventor someone who saw your drawing?
Yeah,
Was he, were you listed as an inventor?
no. As a matter of
So,
fact, I got a call from a friend of mine and said, hey, your idea has been patented and your name is not there.
okay. So, if what you're telling me is correct, that person who claiming inventorship, that company and attorney, if they know what's going on, committed patent fraud, and that patent is invalid.
Well, we talk now about a few years have gone by, but are you protected if I had that drawing in my notebook? Are you protected somehow?
Not really. So the only protection you have is someone steals your drawing from your notebook, they see it or you tell them about it and they file a patent, is you can attack it on inventorship that they didn't invent it, you're the inventor. However, one of the ways, if you don't want to file a patent, is file a journal article about what you did, so that at least this way, you can always go back and say, look, that's not your idea. I published it in this journal.
Mhm.
At least that way you get the credit for it.
Yeah.
And you
see.
know what? Being recognized as the expert is very important. Now, I'll tell you a story about why patents can be valuable, but why sometimes you don't need patents. I met a serial entrepreneur, and he's talked about this, professor from University of Texas. As a professor, he's done, I think, at least 5 successful startups with very profitable exits. And one of the issues with being a professor is the university owns all your inventions and ideas. And they'll file a patent, and then you have to deal with the university business office. Well, this professor didn't want to deal with the university business office because they can be difficult. You have to negotiate with them, you have to have agreements in place, and sometimes the universities are unreasonable in their expectations, and there's no point in, they won't get, for example, they won't give you exclusivity. So why would you take all the time and risk of creating a product to market when you're not going to have exclusivity there? The university is just going to sell it to your competitor, and then all that time and effort. So what this professor did is, rather than file patents on his ideas, he published the ideas, and he got permission from the university to publish his ideas, and universities like publications, and he published it in all the detail that you would a patent application. And then at that point, it was in the public domain, and he would launch a startup, him with some students, on the information that was in the publication, and they would create a very valuable business on it. And his theory was that, yes, someone could steal the technology, but because he was the first one to market, because he had the expertise, he had a major advantage. And for him, that major advantage of being the first one to market and getting it to market was worth more than having a patent and having to deal with an annoying business office. And he successfully launched 5 startups. Now, he said if he didn't have to deal with the business office, he probably would have filed a patent on it. But you know what? It just shows the most important thing is to take it to market and get it. So a publication could be very valuable, because he got permission to publish it. It's in the public domain, so he doesn't have to worry about the university coming around and saying, oh, that's our idea, we're going to file a patent on it now. It's in the public domain. Everyone recognized him as the authoritative author of that concept. So even if someone wants to come and compete with them, they're going to be known, they're going to come late in the game. They're not going to be known as the authoritative expert on it. And most people want to go to the expert on who knows best about it. So he still has a market advantage by the publication. So that's an example where you would use a publication instead of a patent.
Understood.
And I thought it was a creative way of dealing with a very difficult bureaucracy.
Yeah. What is the you mentioned something called FTO opinion, need FTO opinion. What is FTO?
So an FTO is the freedom to operate. And when you launch a product or service, you want to make sure that you're not infringing upon anyone else's patents. So a lot of times they'll do a search in which they'll hire a law firm or an outside searching firm to search what patents are out there in the jurisdictions that they're going to launch the product. And if there's anything related, they take a deep look and see if they're infringing on the claims. If they are, they could get a license or determine if the patent's invalid, or they could design around it so the product is not infringing upon it. So, if you have a valuable product or service that you're launching, it's usually a good idea to do freedom to operate so you know what's out there.
Thank you. About the prior art you mentioned, how do you find out about the prior art to make sure what you're trying to patent is not out there done by someone else?
So that's why you do a search.
Publication?
Yeah, you do a publication search.
Mm-hmm.
Now, publications and patents are different. So a publication could be a YouTube video or a paper,
Mm-hmm.
But that's not a bar for your patentability. That's just a public disclosure. So, that doesn't prevent you from practicing. That just prevents you from potentially patenting the idea.
Mm-hmm.
A patent can actually, like we said, gives you rights to exclusively make, use, or practice. So that could actually be a bar. So those are the things to consider. So, and generally, patents are looked at more by the patent office because the level of detail in a patent is usually much more than in a publication. Not always, but typically. So if someone's filed a patent, generally it's a full enabling disclosure. A lot of the publications, they may mention a concept or two that's similar, but it's not the breadth required in order to invalidate a patent.
So if you go to the patent office to search all that, you probably would use broad keywords to narrow it down, right? And then
yes, there's two ways to search. The easiest way is a keyword search.
Mm-hmm.
Another way that's also valuable, which the patent office does, is they search drawings actually, and they look for commonality in the drawings. They have the ability to see what are the similar drawings out there. And that's also very, very valuable too, because sometimes you could describe things differently, which is actually very important too. The more ways you could describe the same invention, the better off you are, because that gives you more value too.
I see. Okay. Yeah. And going back to the European patent, you mentioned about European patent office. It does European Union, and European Union is 19 members probably, whereas Europe is more than 19 countries. So is European patent office covers entire Europe, or Euro countries has a different one as well?
I think it covers the entire Eurozone. Basically, the only country that's no longer going to be part of the EPO,
Mhm.
in what we call mainland Europe would, I guess, be the United Kingdom.
Mhm.
Right now, I guess until they complete Brexit,
Mhm.
they're still technically part of the EPO. Now, the only probably other countries that are in Europe that are not part of the EPO
Mhm.
is, I think, Russia and maybe, you know, I'm not sure if Ukraine is, or Belarus and the Kazakhstan. I think they're not, so I'd have to check at that. But
Mhm.
you know, it's you know, very rarely have I had clients that wanted to file a patent in Russia. Now, if you're oil and gas, you might want to consider Russia because they actually produce a lot of petroleum products. But
Yeah.
generally speaking, uh, when I get the list of countries, the EPO provides the protection they need.
Okay. Okay. You said that there are 148 countries or something, or 168. Well, you give us the
Yeah,
number.
let me. I
163 or
think
148.
yeah,
But
that was when I did that slide a couple of years ago. I think that number's gone up. I think there's been a bunch of countries. Um, countries do join and leave, so
I see.
that number is always changing. But
Mhm.
I can't think of a country that you would actually want to file in that's not on that PCT list.
You see. Is China a part of those 148 countries, or it is
Yes,
still
China
not?
is.
It is. I see. Okay.
Now, China is a signatory to most of the the IP treaties,
Mm-hmm.
and actually China has strong IP laws. The problem is in the enforcement.
Enforcement, yeah.
And the problem is, the bigger problem is the judiciary. Now, they are trying to publish patent decisions, trying to create a higher level court for reviewing patent decisions to
Mhm.
create some uniformity. Now, one of the problems is if you do file a patent infringement suit in China, what happens is their hearings actually from the outside look very fair and open. So what will happen is you'll get a hearing in front of a judge, and unlike in the US where you have very powerful discovery, you'll get called into court on a certain date, and the other side knows about this date, obviously, and you know about it, and the judge will say, what proof do you have? And you usually say, this is the product. And they'll say, well, how do you know it's coming from that manufacturer? They say, because so-and-so said, well, the judge will say, we will need absolute proof. They'll say, let's go to that factory. And the judge and you and the other side will go to the factory, and the judge will say, go through all their files, go through their warehouse, show me that they're infringing their patent. And the other side by that time has gotten rid of all the evidence. So, and at the end of the day, the judge will say, you went through the computer records, you went through the factory, show me what you have. And if you don't have anything, the judge will rule against you. Now, they feel that is a fair patent, but anyone who knows this is knows what's going on knows that that's not real, because what happened is the factory has gotten rid of any evidence when you do go to the inspection.
Yeah. Okay.
Now, I do think China will change,
I think so. Yeah.
because as China becomes more advanced technology-wise,
Mhm.
they're going to want advanced technology research, and they're going to want advanced technology to come to their country, and they're going to want to protect their own people.
Exactly.
So in order to do that, they're going to have to get much more robust systems in place to protect the intellectual property,
Mhm.
but they're not there yet.
Yeah, in their best interest, they have to go that route. Yeah, in the
Yes, because
long
you
term.
know,
Yeah.
there's obviously there's value from right now for them knocking off and other people's technology, but as a society, that's only going to get you so far. The real value is being the innovator and being ahead of everyone else.
Yeah. So, but the European patent office that will cover only Europe. But if you want to go to other countries, China is not in Europe, in Asia. So you have to have international patent or country by country patent.
Yeah, and China, not only is it an enforcement issue, it's also very expensive. The filing fees are very expensive, and you have to pay to translate it into Chinese.
Oh, boy, yeah.
So,
Yes,
you
right.
know, you're talking, 5,000 probably initially in translation and filing fees and attorney's fees
Mm-hmm.
to file in China.
Yeah, that's right. Yeah, yeah. So what about the rest of the countries in Asia? You have to do a separate filing for those countries as well?
Yes. So,
Pick and choose?
India, I actually like because,
Australia, New Zealand.
yeah, and the reason why I like filing in India is they don't have the best patent history and patent courts in the world,
No.
but their court system is based on the UK system. They
Yeah.
are fighting corruption. They have UK-based laws, so the laws are generally good, and it's fairly inexpensive to file, and they'll accept the filing in English. So for under $1,000, you could file in India.
Mhm.
Yes, like China, they're improving their intellectual property protection.
Mhm.
But for me, you're filing, you're covering a billion people, a marketplace of a billion people.
Mhm.
You're covering a good portion of the world GDP for under $1,000 initially. That's not a bad deal.
Mhm. Mhm. Yeah, that's right. Okay.
China, if you're gonna have to spend $5,000, yes, they're the second most valuable economic country to the U.S.
Mhm.
Yes, I think they're still the most populous country,
Mhm.
but you're paying 5,000 for knowing it's very difficult to enforce, and so
Yeah.
if you're going to spend in India, I'd much rather. Now, what I tell my clients are, that want international protection and can't afford to file in scores of countries, is I like Singapore
Yes.
as a country to filing, and for several reasons. It's not cheap, but it's not expensive. It's a couple $1,000s to file in Singapore.
Mhm.
They accept a English because they speak English. They're a former UK colony.
Yeah, British colony.
They have a very good court system. It's based on the UK court system.
Mhm.
Excellent, outstanding history in protecting intellectual property.
Yeah.
And they're the main shipping hub for commerce in Asia. I think
Yeah.
don't quote me if I'm wrong. I think 80% of shipping in Asia goes through Singapore.
That's right.
So,
You're right.
I tell people if you want to protect Asia,
Mhm.
file a patent in Singapore, and if someone's shipping a counterfeit product that infringes on your patent, wait till that container goes to Singapore, file a lawsuit in Singapore, and you can have a Singapore judge issue an injunction and confiscate everything that's on that shipping container that's infringing, and that's a huge deterrent.
Mhm. Yes, that's right.
So, if someone in China wants to infringe and they say, all right, you have a patent in the US, I won't sell in the US, but yet I'm going to go ahead and sell to Australia.
Mhm.
Chances are that shipment is going through Singapore, and if you know about it, you could stop it in Singapore.
I see. Okay. Yeah. You mean if it, so if it doesn't go through Singapore, how are you going to stop it? Only if it goes through Singapore, right? Then you can stop it, right?
Yeah, if it goes, but 80, if my number is correct, I don't know if it's still that way. At one point, I think 80% of commerce, shipping commerce, went through Singapore.
Yes, you were right. I think to the best of my knowledge, that is what it is. It's, nearly 80%. And Singapore is one of the largest shipping port, and it has one of the largest shipping business in the world as well. And they do
Yeah.
a lot of manufactures a lot of ships as well. A friend of
Yeah,
mine
so-
works in that industry over there. He's an engineer, naval architect. I mean, yeah.
Yeah, so chances are, if a company is shipping through Asia, they have to go through Singapore.
And on the corruption index, I mean, they're one of the least corrupt. I think in the top best countries in the world, the top 5 countries, I think, in terms of corruption index, to the best of my recollection.
Yeah.
Yeah.
So their patent office is excellent.
Yes.
Their patent laws are based on the UK laws, which are very similar to the US and
Mhm.
provide very strong protection. Their court systems are modeled after UK court systems, and they've done an excellent job in providing fair jurisdiction. So it's a great place to do business. It's a great place to if you have to enforce IP rights, to enforce IP rights.
Yes. Yeah, that's right. Yeah.
And unlike other places, they're not hostile to Americans. So being an American suing in the court isn't going to work against you.
They're more or less like a non-aligned country. They're pretty neutral.
Yeah,
Yeah.
pretty neutral. So I do believe if you're if you're challenging someone from Singapore or someone from Asia, you're going to get a fair hearing in Singapore.
Yeah, that's right. Yeah, I think so. So you talked about corruption index. On the other hand, if you decide to patent internationally based on the corruption index, I mean,
What's that? Yeah, so I look,
corruption
if
index.
someone wants to file, I look at the corruption index. So I actually, when I worked for Exxon, created a matrix on how to file internationally, and we had all these different factors, and the corruption index was one of the factors. The total market size of the economy was another factor. The sales in that country was a factor. Competitor activity was a factor. And the other thing was cost of filing was a factor. So if a competitor was operating in South America, sometimes we would file in only one country in South America
Mhm.
because we could block, it would just be very difficult for them to sell in one country and not the rest.
Mm.
So for example, on lubricants, there's several major players that sell lubricants, and they have one trade office for all of South America and one product line. And so they're not set up to sell one product in one country and not another in another country.
Mhm. Yeah. So, yeah. Well, Francisco, do you have any other questions?
No, as a matter of fact, I was going to offer to you to stop the recording in a little bit. I have no questions. However, my level of admiration for Gary has come up during this presentation.
Oh, thank you.
Yeah.
You've done an awesome job.
Yeah.
Okay, awesome. Yeah.
Okay.
And
It was very enlightening because somehow a lot of people like us that we have some oil field background, we're dealing with patent issues and some were incorrect, misunderstandings. But you brought it home when you said, take it to market. I mean, that was awesome. the whole presentation, that phrase was awesome. Take it to market. Personally, I didn't know. I have a couple of patents. You know, they've been done by the company I worked for before, but I never knew that I could take it to market while the patent pending is going on.
Yeah, that's one of the biggest mistakes people do is
Yeah.
they don't take it to market, and they lose momentum.
Mhm.
You know, not all my clients listen to me, but if they do, they take it to market.
Yeah.
All right.
Yep.
Can you say the goodbye, Salim, so we can close the recording?
One other quick question to Gary. Gary, is that patent protection is approved in general for 20 years, or it varies from industry to industry and product to product?
So it's it used to be 17 years from issuance.
Yeah.
Now it's 20 years from date of filing, and that's the date of filing on the non-provisional.
How do you distinguish between non-provisional and provision?
By the number. So the provisional,
Is it
so
formal?
huh?
Provisional is a formal one, right?
Is the old one. It doesn't get published. And then the non-provisional is the one that actually gets examined. So, which is one of the reasons there's some attorneys who say not to file provisional because you should have the disclosure in good enough shape that you should be able to file non-provisional. At that point, why file non-provisional? I don't agree with that. And the reason why I don't agree with that is I like to file the provisional, give the inventor a year to take it to market and develop improvements, and then file the non-provisional. If they improve the technology, great, we update it. If they don't improve it, we just file exactly what we did provisionally if it's ready to go and get the non-provisional. It doesn't hurt you under 20 years, and you don't have to worry about being the first to the patent office because the provisional gives you the timestamp. So I look at a provisional as great, get the extra year, and that gives you an extra year to take it to market, and it doesn't count against your 20-year term. So I look at it as win-win-win. Now,
So when you say non-provisional, I thought my understanding was non-provisional is not official, but provisional is official. Is that correct or not?
provisional is just a placeholder. Non-provisional is the patent application that gets filed.
Oh, I see. So what's the point of putting in a placeholder?
Because it's cheap. It gives you a year to improve the invention. It immediately gives you a timestamp. Provisional, I think, for a small inventor is $120 or $130, 65 for a micro entity. Patent application is several hundred. If you don't have formal drawings, you could have sketches or pictures. You don't have to have claims, and then you can update it before you file the non-provisional.
I see. Okay.
So I recommend my clients now. In all fairness, there are some attorneys who don't like provisionals. They like going non-provisional, and what they'll say is that a lot of times the inventors are lazy and they don't put enough information in the provisional, so it doesn't get you a good timestamp.
Yeah.
I'm like, fine, let's develop the application so it's as good as quality as a non-provisional, but I'll still file it provisionally unless I'm told otherwise.
So 20 years, you say, from the time of provisional submission, or 20 years from the time of
Non-provisional.
non-provisional?
20 years from non-provisional.
Non-provisional, okay. Okay, I think we have a lot of questions that we discussed with Gary. It is so wonderful. Your depth of knowledge is so much unbelievable. So thank you so much.
Awesome.
Well, the experience really counts, right?
Yeah. So you know what? Hopefully take your ideas to market. If you think they're valuable enough to get a patent, or talk to me or another patent attorney that you trust, and and let's this is one way to have a very great career, is to put value on your intellectual property. And like I said, IP is very important, but what's more important is taking it to market.
Yeah.
Great
that's
message.
right. Thanks. Gary, one last question. Sorry. Brookings Institute, is that any way affiliated with the patent office?
What is
Brookings Institute?
Brookings?
Yeah, in Washington, D.C.
No,
It's a
that's
think tank.
a very prestigious think tank.
Think tank, yeah, yeah, yeah.
Yeah, so they have nothing to do with the patent. I'm sure
I see.
they have people in that institute that are knowledgeable in intellectual property,
Mhm.
but basically they're a prestigious think tank. They offer courses on various subjects, but they have nothing. I don't even think they're affiliated with the government, although the government uses them a lot. They do a
Mhm.
lot of work for the government,
I see.
politicians and agencies, but they're separate from the government. Whereas
Okay.
the
Yeah.
patent office is a government agency. It's part of the Department of Commerce.
It's a Department of Commerce. I see. Okay.
Yeah.
Mhm.
And one of the facts is other than the IRS, the patent office is the only other agency that consistently makes a profit for the federal government.
Really?
Last I checked, they brought in over $1 billion more than what they spent. So the patent fees and maintenance fees on the patents not only covers the cost of the agency, it makes the government over $1 billion a year.
Really? Oh, that's unbelievable. Yeah, IRS is always going to make money.
Yeah, IRS has to make money, but the fact is the patent office
Yeah.
consistently also makes money.
Mhm. I see. Okay.
And some people argue the patent office does it by providing a valuable product and service to the people who use it. A lot of people will question the IRS on that.
Well, yes, that's that's true. The obvious reason, right? Yeah. Thanks a lot, Gary. We appreciate it so much. Yeah.
Okay.
Okay. Okay. You
All
take
right.
care.
Best of luck, everyone. Be well.
To you too, and be safe, and have a good weekend as well. Okay.
All right. Be well.
Okay. Francisco, if you can conclude it. Okay. You take care too, Francisco.
Yeah.
Yeah. All the best. Good weekend.